रावल। भावेश शंभूभाई रावल।
फिर बदल दिया क्यों? फिर बदल दिया।
भावेश चंदूलाल रावल। भावेश चंदूलाल रावल। वकील डीजी दर्जी। वकील सी डीजी दर्जी। राजूभाई गोविंदभाई। राजूभाई गोविंदभाई। वकील सी अमर भट्ट। वकील सी अमर भट्ट। हर्षदभाई केशवलाल। हर्षदभाई केशवलाल। वकील सी अनर माथुर। हर्षदभाई। नरेशभाई प्रदेश।
हाँ जी सर।
सामने तरफ से नरेश भाई।
दलील के लिए है।
दलील सर उनकी वजह पे
आपके वकील साहब बुला लीजिए जल्दी।
ठीक।
हाँ वो करेक्शन के लिए दिया।
हाँ।
नैना हिम्मतलाल।
हाँ जी।
नैना हिम्मतलाल।
सर कुछ करेक्शन के लिए दिया, 15-20 मिनट लगेंगे। ठीक है। ये नहीं है अनिल जी आराम।
अनिल जीआरएम यादव। अनिल जीआरएम यादव। वकील सी आरएन जा सकिया। आरएन जा सकिया। वकील सी आरएन जा सकिया। निकिता पोपटलाल परमार। निकिता पोपटलाल परमार। वकील सी एमडी पटेल। वकील सी एमडी पटेल। कानूसी अमाजी मकवाणा। कानूसी अमाजी मकवाणा। वकील सी एचजे वाघेला। वकील सी एचजे वाघेला। वकील सी एसजे वाघेला। महेंद्र राम स्वयंवर। महेंद्र रामचरण। राम स्वयंवर। महेंद्र राम स्वयंवर।
समझ नहीं आ रहा।
महेंद्र राम स्वयंवर। निशांत अरविंद भाई। निशांत अरविंद भाई। वकील श्री के एन पटेल। वकील श्री के एम पटेल। मनोज भाई दाबा भाई। मनोज भाई दाबा भाई।
नहीं अभी हमारे पास है ना कुछ और, वो रोहित साहब से कहीं वो है ना।
मनोज भाई दाबा वकील लोग।
हमारा वकील साहब
साहब
डेली सोनू बना लगा।
हाँ ये
23-7 તારીખ છે એના પહેલા જોઈ લો।
23-7 તારીખે વકીલને લઈને આવો। સરકારી વકીલ પીડી વ્યાસ। સરકારી વકીલ પીડી વ્યાસ। वकील सीपी राणा। वकील श्री सीपी राणा। वकील श्री एचके पटेल। वकील श्री एचके पटेल। वकील श्री एचके पंचाल। वकील श्री आरआर पटेल। वकील श्री आरआर पटेल। वकील श्री एएच पटेल। वकील श्री जेएच पटेल। वकील श्री एएच पटेल। वकील श्री केवी शैलर। वकील श्री केवी शैलर। वकील श्री केवी शैलर। वकील श्री केजी पटेल। वकील श्री केजी पटेल। वकील श्री एचपी शाह। वकील श्री एचपी शाह। वकील श्री जेएस आसोडिया। वकील सी जे एस आसोटिया, वकील सी एस एस पारेख, वकील सी एच एच पारेख, एस एस पारेख, वकील सी एस एस पारेख, वकील सी एवी राठौड़, वकील सी डी एच भट्ट, वकील सी बी एच भट्ट, वकील सी एच बी गोहिल, वकील सी एच बी गोहिल,
एसवी तो बोल ही नहीं रहा, वो क्या कह रहे हैं? क्या नाम बोला?
एच बी
एस
वकील सी एच बी गोहिल,
क्या दिया ये?
अरे ना भाई की बात कर रहा हूं।
सर कब हुई डेथ? डेथ कब हुई?
22 तारीख પછી આપણ उसका
सर
भाई गुजरी
डेथ
गया
कब हुई पूछ
चलो भाई गुजरी गयो सर साहिब
वही पूछ रहा हूँ सर, कब?
2 दिन हुए हैं आज मैंने पहले भी फोन से बात कर ली थी और आज भी
तो
की
इसमें
तो
तो 1 साल हो गया।
आज जी सर हो गए सर
फिर
22 तारीख के बाद में सब एक डेट है उसका ब्रदर गुजरा है तो सर मैंने आज भी बुलाया कि आजा आजा
मैं
आजा
आज का कह ही नहीं रहा सर, मैं तो कह रहा हूँ आपने एडवांस कॉपी तक नहीं दी, 1 साल हो गया।
इसको कॉपी तो सब दे देंगे उसको
कब दे देंगे? कब देनी थी? आज के लिए तो मैं नहीं कह रहा कुछ भी, आज का रीजन है ठीक है, बट जो काम पहले होना था वो 1 साल से क्यों नहीं हुआ? उसका कोई फर्क नहीं पड़ता, आज के लिए एक्सक्यूज चाहिए बस, हो गया काम। प्रेविस 6 लास्ट अपॉर्चुनिटी,
जी सर
एडवांस कॉपी, एडवांस कॉपी दे देना उन्हें, क्रॉस के लिए है डेट।
वकील सी एच बी शाह, वकील सी एच बी शाह, वकील सी एम जे परीख, वकील सी एम जे परीख, वकील सी बी डी शाह, वकील सी बी डी शाह, वकील सी पी डी रंगरा,
आप हैं इसमें? किसके लिए?
सोने नंबर 13 और 14 को
आपने रिटर्न स्टेटमेंट देनी है, कॉपी सप्लाई कर दी,
कॉपी
कॉपी दे के फिर फाइल करिए ना।
तमिलनाडु रिसीव करें,
हमारी जोड़े एक्स्ट्रा कॉपी चाहिए अच्छा हमारी रिसीव करें
रिसीव करेंगे।
हम्म,
वकील सी एच एस पारेख, वकील सी एच एस पारेख, एस एस
मेरे भी नाम नहीं बोल सकता।
वकील सी एस एस पारेख, वकील सी वाईसी लेहुआ, वकील सी गांधी लेहुआ, वकील सी वाईसी लेहुआ,
1 मिनट इधर आओ, तुम यहाँ आओ, नाम सुन के फिर जाओ, क्योंकि तुम पढ़ के भी नहीं बोल सकते, वहां से सुन भी नहीं सकते, यहाँ आके पूछ के जाओ। क्या ओके? आओ फिर। ओके क्या? ओके का मतलब क्या?
वकील सी के एस मेहता, वकील सी के एस मेहता, वकील सी पी आर पटेल, वकील सी पी आर पटेल, वकील सी पीजे प्रजापति, वकील सी पीजे प्रजापति, वकील सी एमजे दीवान, वकील सी एमजे दीवान, वकील सी एमके परमार, वकील सी एमके परमार,
यहाँ आने को कहा तो वहीं से सुनाई देने लगा था, इसका तो जानबूझ के ध्यान ही नहीं देना।
वकील सी आर के ठाकुर, वकील सी आर के ठाकुर, वकील सी बी एस परमार, वकील सी बी एस परमार, वकील सी एस एन शाह, वकील सी एस एन शाह, वकील सी ए एस सैयद, वकील सी ए एस सैयद, वकील सी सी एन दर्जी, वकील सी एन दर्जी,
सब
वकील सी एम एस नायक,
हम्म,
वकील सी एम एस नायक,
एप्लीकेंट की तरफ से हो,
वकील श्री MS वोहरा, वकील श्री MS वोहरा,
ट्रांसफर हो गया ये सब, डिले अर्जी है, 50 दिन का डिले। पहले ऑर्डर पे थी लेकिन अब फिर से आपके यहाँ कर देंगे सर।
ये लोग आ जाए तो आज ही कर लो।
जी सर जी।
वकील श्री DA रावल, वकील श्री DA रावल, वकील श्री BL पटेल, वकील श्री BL पटेल, BL पटेल, वकील श्री AM मंसूरी, वकील श्री AM मंसूरी,
સાહેબ 1200 જોડવા માટેની અરજી આપેલી હતી, એમાં સામાવાળાએ વાંધો નથી એવું લખી દીધું છે કે 1200 જોડવામાં આવે તો વાંધો નથી, અરજી ઉપર મેન્શન કરેલું છે।
एक बार कॉल कर ले फिर देखता हूँ।
જી સર।
इनको बुला लो अगर है ये कोई रिस्पोंडेंट के लिए कोई आता है।
नहीं मैं नहीं जानता हूँ एडवोकेट।
वेट कर लेते थोड़ी देर, देख लेते हैं।
जी सर।
वकील श्री BR ठाकुर, वकील श्री BR ठाकुर, वकील श्री JR राठौड़, वकील श्री JR राठौड़, वकील श्री UB प्रजापति, वकील श्री UB प्रजापति, वकील श्री MB गोहिल, वकील श्री MB गोहिल,
UB प्रजापति। हेलो, behalf of Mr. MB Goyal।
यस,
I am for response। सर हाई कोर्ट में सर एक सप्लीमेंट्री 2 पे बोर्ड है, कीप बैक प्लीज रिक्वेस्ट है सर, आ रहे हैं।
On the last occasion, he mentioned that he'll not press this. Let us see what happens. This is the transfer application along with injunction application.
लेट हिम कम।
Oh, please. Right.
प्रजापति,
हाँ जी, नोटिस। अठारह सौ।
वकील श्री JM भावसार, वकील श्री JM भावसार, वकील श्री GH परमार, वकील श्री GH परमार, वकील श्री TB भट्ट, वकील श्री TB भट्ट, वकील श्री KM कड़िया, वकील श्री KM कड़िया, वकील श्री JR राठौड़, वकील श्री JR राठौड़, वकील श्री AJ टापरिया, वकील श्री AJ टापरिया, वकील श्री KN राजपूत, वकील श्री KN राजपूत,
ये सारी ट्रांसफर की कहाँ से आई हैं?
वकील श्री SP दवे,
आज सर ये ट्रांसफर होके आई है, मैं एक्नॉलेजमेंट दे रहा हूँ क्योंकि पब्लिक नोटिस से सम ऑफ द रिस्पोंडेंट को सर्व किया था, कोर्ट ने ऑर्डर पे लिखा था एक्स पार्टी के लिए, उसके बाद में फाइनल हियरिंग के मेरे को थोड़ा एग्जिबिट लेना है तो इस टाइम चाहिए, उनको बताया
18/7।
ऑब्लाइज।
वकील श्री GL टांग, वकील श्री GL टांग, वकील श्री HK पंचाल, वकील श्री HK पंचाल, वकील श्री AK मंसूरी, वकील श्री AK मंसूरी, वकील श्री AA शेख, वकील श्री AA शेख, वकील श्री AS सैयद, वकील श्री KS सैयद,
सीरियल नंबर 39 एप्लीकेंट की तरफ से हो, कॉल फॉर रिकॉर्ड करने का सर, रिकॉर्ड आ जाओ तो ट्रांसफर हो क्या ये
फॉर रिकॉर्ड एंड आर्गुमेंट 22nd of July।
जी सर। ठीक है।
वकील श्री AS
23 रिक्वेस्ट 23 जी सर।
लास्ट वाला
वकील श्री AS भट्ट, वकील श्री AS भट्ट,
पराग भाई से जजमेंट लेके आएंगे। चल।
वकील सी एवी बघेल, एवी बघेल, वकील सी एवी बघेल, एवी बघेल, एवी बघेल, वकील सी एवी बघेल,
अरे यार। क्या नाम बोला?
एवी नहीं एवी वकील
હું
सी
સાહેબ એચએસ પંડ્યા છું મારા સાથે છે અને અમે આમ તો આ સેશનમાં સાથે
सर मुदतर जी है आईओ की, तो આવતીકાલે
આમ તો એનબીડબ્લ્યુ ના કામ કસ્ટડીમાં લીધેલા છે.
एनवीडी
हाँ, साहब।
क्या करना है?
વસમાઈ સાહેબ 3000 ના દંડ કરીને છોડાયા હતા કોસ્ટના કારણે. આઈ એમ ઓલ્સો હેલ્પલેસ बिकॉज
फाइल निकलवा लो, देख लेता हूँ सर, फाइल
जी।
निकलवा लो।
जी सर
5 मिनट रुकिए।
सब सिविल कोड पर 4 नंबर 2019
हाँ जी।
એમાં સાહેબ સામાવાળા તરફે છું કેસ સેલોત સાહેબે કીધું બપોર પછી રખાવજો કે બપોરે સવારે હાઈકોર્ટનું પતાવીને આવી ગઈશ એટલે બંને જોડે એડવોકેટ આવવાના છે ચીફ
सीरियल नंबर 2 क्रिमिनल में
हम्म।
we have filed वकालतनामा at previous date
और appellant,
for respondent
you are for
sorry appellant
हम्म।
हम कॉम्प्रोमाइज के लिए रेडी है हमारे पहले जो एडवोकेट थे तब ऑन बोर्ड कुछ बात हुई थी तो
सर वो बात डेट पे क्यों होती है?
नहीं प्रीवियस डेट पे भी मैंने यहाँ बिठा के बात की थी ऑनरेबल कोर्ट ऑन
कब थी प्रीवियस डेट, कब थी?
1 महीने पहले थी
1 महीने में तो हो जाना चाहिए ना
हाँ
सर।
तो मैंने कॉम्प्रोमाइज का बोला तो उनका क्लाइंट चेक मल्टीप्लाई 5 मांग रहा है 10 लाख का चेक है वो 50 मांग रहा है तो
वो तो फिर नहीं पॉसिबल सर।
तो फिर
10
मैंने
के 12-15 की बात हो तो कुछ बात
अब वही
हो
तो
सके।
बात है तो वो कंप्लेनेंट के
મના कर रहे हैं
ठीक है, दलील करिए फिर देखिए।
तो मैं आज
वही
तो
रखते हैं।
मैं मुझे मेरे क्लाइंट ने बताया था कि कॉम्प्रोमाइज करना है कि नहीं ये डिसाइड करके जाना है हम पिछली बार आए थे और
सर
डेट
क्या
में-
डिसाइड करेंगे 5 टाइम्स में, बताइए।
हाँ तो वो तो
स्टिल यू
हम
वांट टू टॉक कि 5 टाइम्स नहीं 4 टाइम्स ले लो,
नहीं
फिर क्या डिसाइड करना है?
ऑनरेबल कोर्ट ने जो बोला 10 की जगह 12 वो ठीक है अभी भी
सर मैं ठीक नहीं कह रहा, मैं ये कह रहा हूँ अगर ऐसी बात होती 10-15 तो
जी,
बात हो सकती थी।
जी 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 जी
आप 5 टाइम्स कह रहे हैं तो मैं भी कुछ नहीं कह सकता कि बात करें। मेरी तरफ से कोई प्रपोजल नहीं है, उसे ये मत लीजिए कि मैंने
नहीं
इतना कह दिया।
ऐसा नहीं ये तो जनरल टॉक्स है ऐसी बात
हम्म।
नहीं है तो अगर कॉम्प्रोमाइज हो जाता है तो उन दोनों को भी फर्दर एक्सरसाइज से
सर वो
बच
आप
जाते हैं।
देखिए, मेरी कहीं बीच में जरूरत है कुछ है तो मीडिएशन में भेज सकता हूँ, बट कंप्रोमाइज तो आपका है, मैं दोनों में से किसी को फोर्स नहीं कर सकता।
तो मीडिएशन में
लेकिन
जाऊं
5 टाइम्स में तो मीडिएशन का भी कोई फायदा नहीं ना।
मीडिएशन में जाऊं से मीडिएशन में नहीं जाऊं तो
ठीक है,
सर
दलील कर दीजिए।
तो सर मैं एक 15 दिन की डेट चाहूंगा क्योंकि पिछली बार ही मैंने वीपी फाइल किया है और आज मैं इस तरीके से आया था
बीपी की कितनी डेट की बात करते हैं?
फिर ऑनरेबल कोर्ट को जो शूट लगती है उस डेट को मैं
70
रिटर्न आर्ग्यूमेंट और दोनों कर दूं
70-7 ओरल कर देना सर, रिटर्न आपकी चॉइस है, देना चाहे तो दे दें।
ऑब्लाइज मच
सर वो पेलेंट ने 1 लाख रुपए जमा किए थे उसकी कोशिश मैंने दी है जी।
देख लेंगे वो भी नेक्स्ट।
उसमें सर एक मेरा ऑब्जेक्शन ये है कि ऑनरेबल लोअर कोर्ट ने ऑर्डर किया है
लोअर कोर्ट नहीं होती सर,
सॉरी
लोअर कोर्ट नहीं है कोई,
जुडिशियल कोर्ट में जो
ट्रायल कोर्ट है।
ट्रायल कोर्ट ने जो ऑर्डर किया है वो ट्रायल कोर्ट के ऑर्डर में ऐसा 10 लाख का चेक था तो 15 लाख का ऑर्डर किया है उसमें 10 लाख इनको देने थे तो 5 लाख कोर्ट में रहने थे तो उनको 10 लाख का ही 20% मिल सकता है तो वो 15 लाख का 20% क्लेम कर रहे हैं।
ऐसा कहाँ लिखा है सर?
15 लाख
20% में तो ऐसी बाइफरकेशन कहीं कोई है ही नहीं किसी जजमेंट में।
जब 15 लाख का कॉम्पेंसेशन ऑनरेबल ट्रायल कोर्ट ने किया और उसमें से इनको 10 लाख पे करना ऐसा स्पेसिफिक क्लोज 2 में उन्होंने मेंशन किया।
हाँ,
तो उनको जो 10 लाख लेना है उसका 20% उनको मिलेगा और इसका
कहाँ
5
लिखा है
लाख।
सर? ये कोई किसी जजमेंट में आया है? क्योंकि एक्ट में तो ऐसा कुछ है नहीं, सेक्शन में तो नहीं है।
अब मैं ऑनरेबल कोर्ट को रिक्वेस्ट करूंगा कि ट्रायल कोर्ट का जो कंक्लूजन है लास्ट ऑपरेटिव पैरा
कंक्लूजन
वो
सर 10 लाख और 5 लाख का है,
जी
20% का नहीं है। 20% का वो कोर्ट डिसाइड भी नहीं कर सकती थी, वो तो अपील में ऑर्डर है।
मैं वो जो ऑपरेटिव पैरा है वो ध्यान में लेकर।
सर वो कोई इस कोर्ट के लिए डायरेक्शन है?
सर उनको 20% तो जो उनका अवार्ड है उसका मिल सकता है
कहाँ
ना।
लिखा है सर? ये बताइए ना।
वो 148 में तो 20% ऑफ अवार्ड लिखा है।
हाँ,
तो एक कौन सा अवार्ड, अगर कोर्ट ने ऐसा किया है कि 5 लाख कॉम्पेंसेशन के तौर पे कोर्ट में भरना है तो उसका तो कोर्ट को 20% मिलेगा ना,
नहीं
उनको
ऐसा
कैसे
कुछ नहीं है सर, 20% के टाइम पे कुछ नहीं है।
इट इज ऑब्लिक सर।
आज 15 लाख डिपॉजिट हो, उस टाइम आप कह सकते हैं कि इन्हें 10 देना है, 15 नहीं। लेकिन
ऑब्लिक
20% में तो कोई ऐसा कुछ है ही नहीं बाइफरकेशन के कितने परसेंट इनका है कितना नहीं।
ऑब्लिक सर।
वैसे आज ऑर्डर नहीं कर रहा, डोंट वरी, नेक्स्ट डेट पे देखेंगे।
ऑब्लिक ऑब्लिक
बट ऐसी कोई बाइफरकेशन मैंने नहीं देखी कभी।
ऑब्लिक सर।
पूरी प्रोसेस में है।
हाँ, ये तो वेरी ऑर्डर।
ऑब्लिक
70 साहब को
ऑब्लिक
ક્રિમિનલમાં 5 નંબર છે સાહેબ. સેશન્સ કે
70-18
હા એમાં સાહેબ આરોપીનો રિપોર્ટ આપું છું અને હાઈકોર્ટનું સ્ટેટસ જે છે રજૂ કરું છું.
31-7
સિવિલમાં બે
सिविल में
MCA 24/23
जी स्टेज है में
हाँ सर
31-7 आप किसके लिए सर?
सामावाड़ा SK पंचायत
ठीक
एक
है।
37 नंबर
हाँ,
ट्रांसफर થઈ
मस्ती।
હા 2 નંબરમાં હા એ અરજદાર ગયા હાઈકોર્ટ અરજદાર ગયા એક 37 નંબર હતો
37 में क्या है सर?
ટ્રાન્સફર થઈને આવીએ સાહેબ
सर्विस
સર્વિસમાં સામાવાડા નંબર 1 ને સાહેબ નવા સરનામે બજવવા માટે હતું મેં RPD એમને કરી રહી સ્પીડ પોસ્ટ થી
उसके वो फाइल करें ना, स्टेटस उसका फाइल करें।
હા પણ બજવણી નથી થઈ સાહેબ એવો શેરો આવેલો પાછો
अभी क्या करना है?
સાહેબ આવતી મુદતે હું નવું સરનામું પક્ષકારના પક્ષમાં લાવી દઈશ નવા સરનામું હા આપી
21-7 21 जुलाई 21-7
ને એક 39 નંબર
एमा 23-7
જી સર એમાં સામાવાડા પર
फॉर आर्गुमेंट्स। 61 of 23.
શું નામ આપનું સાહેબ? હું એપેલેટ છું. 2 નંબર.
18-7 for arguments.
સર નોટિસ બજાવણી માટે એડ્રેસ પ્રૂફ જોઈતું હતું સામેવાળાનું તે મેં લાસ્ટ ટાઈમ આપેલું હતું પુરોહિત સાહેબની કોર્ટમાં રજૂ કરેલું હતું પછી આગળ શું થયું એ ખ્યાલ નથી.
દિશાનું સર નામ?
હા યસ યસ
તમારા નોકરીનું બેઠાનું એ તમે લખ્યું.
હા
इसमें गया नहीं सम कर दे.
નોટિસ કાઢી.
એમને નોટિસ બજાવણી થઈ કે નહીં એ ખ્યાલ નથી. પ્રતિવાદી હાજર જ નથી રહેતા.
बनने में सेम છે?
ના ના સર અમે તો
એમાંથી છે ને વિજય પટેલ એમની સ્વીકાર થઈ ગયો.
અચ્છા. તમે ઇન પર્સન છો?
હા હું
16-7.
16-7 થેન્ક યુ સર.
यस. 131. वीपी.
हाँ सर.
वीपी तो फाइल करो.
हाँ मैंने किया है.
देखिए नाम नहीं आ रहा.
હા એમાં આમાં વાળાનું પણ એક જ છે. એ ગુજરી ગયું. એમના વાળો
आए थे एन मंसूरी.
હા એ ત્યાં હતા. અને ફોલો
देखने से क्या होता है.
एक अपन
कर कराना।
वकील जी E and मंसूरी वकील C and मंसूरी
अरेजदार ना वकील आ भी जाए ले लिए।
Please, please. I'm still 75.
26-24
हाँ जी सर।
आप किसके लिए सर?
वो प्रतिवाद नंबर 6 पर 2 6 पर 3 तक रहता है।
दलीलों માટે છે
हाँ आर्ग्यूमेंट માટે सर।
ये आ जाए व्यवस्था साहब तो कब तक? नहीं रात जो लिए।
हाँ जी।
22 હા મેન્શન થઈ ગયું છે ડિલે અરજી છે એમાં સામાવાળા એડવોકેટ નંબર 1 છે એમને મેં કોલ કર્યો એ મેઇન પક્ષકાર છે સાહેબ એમને સાહેબ હજુ 1-1.5 કલાક જેવું થાય એવું છે આ પરમિશન આપો સાહેબ મોર દેન 5 મિનિટ્સ ખાલી ડિલે થશે યસ
કેટલા છે ડિલે?
જી સર
ડિલે કેટલો છે?
સાહેબ આમાં કુલ 10 પ્રતિ સામાવાળા છે
ડિલે કેટલા છે?
50 દિવસ 50 days
આરસીએ ફાઇલ કરવાનો?
નહીં એમસીએ સ્ટે એપ્લિકેશન 5 ઉપરની અપીલ છે સાહેબ અરજદાર છે રમાબેન ભૂપેન્દ્રભાઈ પંચાલ સાહેબ એજેડ છે ઓર્ડર થયો તો સાહેબ 5/6/1/2023 અને સાહેબ બીમારીના કારણે અને વાયરલના અને એજ ફેક્ટરના હિસાબથી અપીલમાં સાહેબ ડિલે થયો છે
મેડિકલ સર્ટિફિકેટ
ને સાહેબ એ સર્ટિફિકેટ રજૂ નથી થયું એ વખતે
कैसे माने?
बेसिक साहब वायरल અને જે
वायरल में तो मेडिसिन ली होगी ना
नहीं
डॉक्टर
सब
को दिखाई
एज
होगा।
फैक्टर के हिसाब से थोड़ा डिले हुआ था स्पेसिफिक सब कोई
सर आप
बड़ी
एज फैक्टर भी कह रहे हैं वायरल भी कह रहे हैं।
हाँ दोनों नो सब बस
वायरल है तो मेडिकल सर्टिफिकेट होगा ना।
मैं रजू कर दूंगा तो सब नेक्स्ट में ऐसा हो तो सब क्योंकि सब बड़ी बीमारी कोई थी नहीं तो सब मैं ऐसा सर्टिफिकेट नहीं लाया कि भाई कोई और सब जो मेन कंटेस्ट चीज है वो सब नंबर 1 परचेजर है मेरा राइट सब मेरे राइट बिना सेल डीड हो गया कैंसलेशन ऑफ सेल डीड का सूट है सब अब सब ये डिले मंजूर होने से सामने वाले को कोई हार्म नहीं होगा
सर पहले मेडिकल सर्टिफिकेट तो दीजिए।
जी सर रजू कर देता हूँ नेक्स्ट डे पर क्योंकि सब 2023 की है तो उसकी वजह से सब
50 दिन का डिले 3 साल इसमें लग गए।
सब कोर्टों में सब आर्ग्यूमेंट हुई ऑर्डर पे गई और फिर ट्रांसफर हो गई ये थर्ड कोर्ट है सब आपकी
आपने किसी में भी सर्टिफिकेट फाइल नहीं किया?
नहीं सब वो स्पेसिफिक बड़ी बीमारी नहीं थी इसके लिए मैंने नहीं किया आई एम
बड़ी ना सही है। आप जिस ग्राउंड पे डिले मांग रहे हैं उसे जस्टिफाई तो करें।
एग्री 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 सर
आप कंडोन करने को कह रहे हैं डिले।
एग्री एग्री सर लेकिन सर मैं सब कोई ऐसा वो नहीं करना चाहता था क्लीन हैंडेड के आने की वजह से मैंने सब नहीं किया बाकी कोई रीजन नहीं है सब मैं कर दूंगा सब मैं कर दूंगा
क्लीन हैंड्स तो शो करिए ना।
हाँ क्लियर इसीलिए सब सर्टिफिकेट कोई ऐसी बड़ी बीमारी नहीं थी तो मैंने सर्टिफिकेट नहीं लिया था वो टाइम पे सर
कब तक लाएंगे?
15-20 दिन की सर
सर्टिफिकेट लेने में 15-20 दिन?
तो सब उनको कांटेक्ट करके वो भेजे तो फिर
एक साथ?
जी सर पब्लिश।
और फाइलिंग ऑफ मेडिकल सर्टिफिकेट।
जी सर, पब्लिश।
क्रिमिनल में 1 नंबर सर,
कौन सा?
1 नंबर।
सिविल में?
क्रिमिनल क्रिमिनल આ सब સામાવાળા તરફથી સર વોરંટ ચાલુ તો સાહેબ જામીનદારને નોટિસ કરવાની અરજી આપું છું।
जमींदार को नोटिस नहीं किया इसमें?
નોટિસ
सोर्ट साहब।
જી સર मतलब
रिस्पोंडेंट के लिए नहीं आया कोई? रिस्पोंडेंट के लिए नहीं आया कोई?
बाहर बैठा है।
अनिल सियाराम यादव।
अनिल भाई, आपके वकील साहब बुलाइए।
मैं फाइल ऑफलाइन साइन कर दूं? हाँ फाइल पैसा उठाड़ा तो सर 20% हमने भरा।
अरे सर, इसमें एक मिस्टेक रह गई, मुझे भी याद नहीं रहा। वो बेल देनी होगी।
हाँ?
बेल।
कोर्सेज पास करते ना, अर्लियर दिया है अपील
हाँ,
की
नहीं, वो इसमें लिखना रह गया शायद।
नहीं, आई विल पास द
क्वेश्चन में रह गया, मुझे याद नहीं
कोर्सेज
रहा।
पास कर देता हूँ, कोर्सेज पास कर देता हूँ जी। ऑब्लाइज यस सर, बात है।
અરે એપ્લિકન્ટ છે
जी।
1200 જોડવા માટેની અરજી આપેલી છે
सर, उसको कैसे जोड़े? 2018 की डेथ है, 2025 में एप्लीकेशन आए। लिमिटेशन कितनी है?
और उनको जो समझ के नोटिस बजट नहीं हुई ना सर, उसके बाद हमको पता चला कि वो डेथ हो गई इसकी।
सर, आपको कभी भी पता चला हो? लॉ क्या है? अबेटमेंट तो ऑटोमेटिक है।
जी।
वो तो 9 दिन पूरे होते ही अबेटमेंट हो गया, उसमें भी कैसे पार्टी बना दें? अब 7 साल के बाद एप्लीकेशन फाइल कर रहे हो,
जी
कैसे बनाए पार्टी?
सर उसके वारसदारी आएगी ना उसमें सर।
कैसे आएगा सर? कोई टाइम लिमिट, कोई चीज है? लिमिटेशन नाम की चीज है ना कोई?
डिले डिले की अर्जी की है ना साहब हमने,
कहाँ दी है?
ये उसमें
कहाँ है, दिखाइए।
मेन एप्लीकेशन के बाद में।
हाँ, नहीं।
મેઇન તમારી ડિલિયર
जी
હા
પછી પેલી
वो
અરજી
तो सीए में जो मेन है वो है ना डिलेयर जी।
जी सर।
અપીલ
उसके-
કરવામાં ડિલે થઈ
હા એટલે એમાં ખબર પડી એમને કે સાહેબ બજવણી થઈ ને એટલે પછી કે ડેથ થયેલું છે સામાવાળાનું.
सर जब डेथ का पता चला आपने एक एप्लीकेशन दी
जी
लीगल एज को कंप्लीट करने के लिए,
जी
वो लीगल एज को कंप्लीट करने के लिए आप डेथ के 7 साल बाद एप्लीकेशन दे रहे हो, उसको कैसे अलाउ करें?
सर हमको तो पता ही नहीं था ना सर. हमें
सर आपको पता होने से कुछ नहीं होगा ना, आपको ना भी पता चला 90 डेज एक्सपायर होते ही अबेट तो हो गया, प्रोसीडिंग्स तो अबेट हो गई.
तो उसके बाद वो फाइल हुई ना साहब हमारी वो
सर,
एप्लीकेशन.
मैं भी तो यही कह रहा हूँ कि उसके बाद फाइल हुई लिमिटेशन के इतने साल बाद.
जो बजवनी हुई है साहब
हाँ तो क्या हुआ?
उसके 90 डेज में हमने वो अर्जी दे दी साहब उसमें.
सर 7 साल के बाद दी है, 90 डेज कौन से? 2018 में डेथ हुई, 2025 में आप एप्लीकेशन दे रहे हैं और कह रहे हैं 90 डेज में दे दी.
तो मैंने तो साहब वो जो फाइल किया वो 2025 में ही किया है ना सर.
सर 2025 में क्यों किया जब 2018 में डेथ हुई?
2018 में मेरे को पता ही नहीं था ना साहब वो डेथ हो गई.
सर एक काम करिए,
जी
किसी सीनियर से एक बार कंसल्ट कर लीजिए
जी
कि इसमें क्या करना है,
पूछ लेता सर.
क्योंकि यहाँ बैठकर आपको मैं सारा लॉ पढ़ा नहीं पाऊंगा.
जी
किसी से एक बार 2 मिनट कंसल्ट कर लीजिए
जी
और फिर बताइए क्या करना है.
जी सर.
जो पिछली बार लगी थी सर, और एक में उन्होंने बोला था कि हमने सेल डीड कर लिया है
29 of 36
सीएल नंबर 29
CMADC 39 of
39
26.
यस 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 दैट वाज सीकिंग ट्रांसफर. जो मैंने बोला था कि पहले उन्होंने हियरिंग पे जब लगाया था बोले कोई अर्जेंसी नहीं है, और उन्होंने 19 जून को फिक्स किया था. फिर हमको ऐसा पता चला कि वो प्रॉपर्टी बेचना चाहते, इसलिए हमने ये एप्लीकेशन लगाई. नोटिस में उनको जो रिस्पॉन्ड नंबर 1 है उनको तो सर्व कर दिया था. उन्होंने आके लास्ट डेट पे ऐसा एक रिकॉर्ड पे रखा था कि हमने इसके अंदर सेल डीड फाइल कर दिया है, मैं कॉपी आपको दे दूंगा. वो सब सेल डीड जब हमने रिकॉर्ड पे देखा तब पता चला कि सेल डीड में उन्होंने उनके साले को ही बेचा है. दैट इज 1. देयर आर 6 ओनर्स ऑफ द प्रॉपर्टी, उसमें सिर्फ 5 ने साइन किया है. और कल यस्टरडे पिछले कल उन्होंने आके पूरा पोजीशन लेने की भी तैयारी कर ली थी. थोड़ा
At
मगजमारी.
present you are in possession.
Yes, we are in possession. There was a stay order from 2014 in the suit, which continued till the final disposal of the suit. फाइनल डिस्पोजल के दिन हमने जो एप्लीकेशन लगाई थी कि भाई इसको अपील पीरियड 30 डेज के लिए स्टे किया जाए, वो खारिज हो गई थी और अपील फाइल कर दिया, अपील को रिले में कर दिया. इसलिए हमने ये ट्रांसफर किया कि हमको ऐसा एसर्शन है कि वो बेच देंगे प्रॉपर्टी, which on the
When
last
you have filed appeal,
yes,
this application should be filed along with the appeal.
no, appeal and stay application both was filed,
हाँ.
but the honorable court, the court number 3, said that no, there is no urgency. Let it go on 19th of June, then we will hear what happens. Therefore, I moved this application seeking transfer that I am in urgency. I may be protected, and this may be either heard by this honorable court or some suitable, which have got time. उन्होंने बोला मेरे पास टाइम नहीं, अभी मैं नहीं सुनूंगा. Very
कौन
respectfully,
सी कोर्ट में था?
Justice Unadkat. So that
Sir,
is
he is
the.
not Justice Unadkat.
I'm sorry.
We pray that he becomes so soon, but at present he
sorry,
is
sir.
not.
I'm sorry. I don't regularly practice here, so my tone, language will be recorded.
You can call him as Mr. Unadkat.
Yes, sir.
Yes.
So learned court, basically. So my difficulty now is that if this is not heard, they'll take possession also, which I have been protected since 2014. And never challenge my laws.
But before that, you have to serve the other respondents.
The same address which we have registered in the suit, wherein the notice was sent, the same address are in the sale deed as well. Unfortunately, one has appeared, the other says we are not served. Now, what I can do is I can take a special bailiff for whatever my lords permits me, but in a short distance time where I can come again and
You
argue.
can take special bailiff. The only thing is, after 10 days, the case is listed there.
I don't want to wait for 10 days, sir. That is why I'm requesting. Because yesterday what has happened is actually my lords, a criminal complaint could have been filed, but somebody intervened and it was stated for के कल सुनाई नहीं है, कल सुन लेते, 2 दिन के बाद देखेंगे. मुझे अप्रिहेंशन ये है सर, आज नहीं तो मैं परसों के लिए मैं डेट देता हूँ, मुझे आज ये स्पेशल बिलीव करके देख सकते हैं अगर, तो परसों मैं फिर इसको आर्ग्यू कर लूंगा। बेकार में सर मारा मारी हो गया, फिर क्रिमिनल कंप्लेंट सारे फैमिली वाले हैं।
But whether you are confident that it will be transferred?
No, I am requesting till that it is transferred, it may be I am requesting, sir, I will be pressing this only because that court said no. I am not choosing a forum, sir. Whatever my court load says.
But a judicial order or adjournment, whether it can be a ground for transfer of case.
I am not saying that. I am saying this, that it is an hearing urgent, therefore either I may be protected till it is heard. I am not asking anything.
I am ready to hear the moment all are served.
Therefore,
You need not argue twice, one for stay and one for transfer.
Lordship, may I
It
request
can be
this
heard on the same day.
this matter may be kept on Thursday. I may be given a special bailiff my lord's notice. I'll get it paid today
Address
itself.
कहाँ पे? कहाँ का address है इसमें? Respondent sir.
लोकल गांधीनगर जमियतपुरा।
फिर सर्विस क्यों नहीं हो रही?
सेलडीट में भी वही एड्रेस है, वही तो बोल रहा हूँ।
क्या रिपोर्ट का है ये? देखो ना ठीक है।
Out of 6 respondents who are owner of the property, 5 have signed. 6 had said no, I will not sign, because, and that person is also confirmed about the agreement to sell, which was executed in our favor in the suit also.
But that is to be seen by that court.
Yes.
I cannot comment on that at present.
What has happened is, it intentionally इसको
ગાંધીનગર એવું એડ્રેસ ગાંધીનગર રહે છે પરંતુ ચોક્કસ તમારી પાસે નહીં.
सेम दस्तावेज ની અંદર પણ સેમ જ એડ્રેસ છે। સેલडीड कॉपी में
इनकी जो ये सीएमए फाइल हुई है उसमें एड्रेस कौन सा है?
This is the copy of sale deed malus which he accepted. In there also same sale address. રહેવાસી શીતલવાસ જમિયતપુરા ગાંધીનગર।
शीतलवास में कोई नंबर नहीं?
No. સિલકદાર વાસ, that is what is stated.
But some number should be there.
ખડકી બસ એટલું જ। Or I may say that the notice to be served on the address which is stated in the sale deed, whatever address.
But even then some number must be there, no?
Yes, in one respondent, Smita Ben Maloj, it says 41 Devbhumi Residency. This is Bawla.
એ પણ 1:2.5
એ જ છે ને, 5 જણા એ જ છે, સેમ 5%. One shows now in Bawla, બાકી બધા જમિયતપુરા, એક ગાર્ડ 307 છે, 307. There is one number, sir, at number 5, 307 સિલકદાર વાસ જમિયતપુરા. 5 number માં લખ્યું છે 307.
But you have not mentioned 307 in your
No,
application.
in the suit malus the same address carries
In
out.
the suit, it is the same address, but
I have
kindly
to match
see
the
your
title, sir.
CMA.
I have to match the title. Now I have, for this sale deed copy malus, I have come to know that this is what is prefixed. If I don't match the title, my appeal will not be circulated.
In suit, number was not there. And suit was filed
By plaintiff malus.
so there it was only
In a minute, sir.
Seetal Das ni Khadki Patel was.
Same. That is
No
what
number.
No. It's an area.
But now its sale deed number
In the
is there.
sale deed now it says 307. So I'll do that. In sale deed malus for number, there is Smita Ben. There is one more address which says of Bawla. So I may be permitted that notice to be issued on all these addresses, my lords.
Do an application for
I'll
serving them on that address.
yes, my lords.
And you
get that
want special bailiff also.
Yes, my lords. Whatever charges are there, I will pay. I will intend to proceed. Maybe since this is of Bawla, if not Thursday, I request for Friday, my lords, so that we can get one more day.
One bailiff for this Seetal Das ni Khadki and one for Bawla.
One for Bawla. Because one is for Jagatpur is also here only, my lords. Number 3, Jaysri Ben Popatbhai shows the address of Jagatpur.
Number 3,
Jaysri Ben Popatbhai Patel. नंबर पे
Yashri Ben is 2/4,
yes madam.
but no separate address is given.
No madam, everyone was staying in same Sital Das Khadke only. Now in the sale deed, this deed which is had now on record madam, it shows Devbhumi 41 Devbhumi Residency, GB Road, Bavada, Ahmedabad. Similarly, number 3 Jayashree Ben shows my lords 101 Parmeshwar Bhoj, Godrej Garden City, Navaranpura, Jagatpur. That is near this Vaishnav Devi marriage.
एप्लीकेशन ले लो, एक बैलिफ गांधीनगर के एड्रेसेस पे 3,000 उसमें, एक बैलिफ बावला और नवरंगपुर. You will take bailiff along with you.
Yes, sir. I'll ask my client to be there.
4,000 में दोनों को एक ही चला जाएगा 4,000.
I'll get the needful documents done, madam. I request for Friday.
Any date you want, sir.
Friday, madam.
Even you want Thursday, I can give Thursday also.
Sir, one is Bavla and Navaranpura. So that एक रह जाएगा, फिर मुझे फिर नोटिस निकालनी है.
Sir, it's up to you.
सेफ सर.
आप साथ में जा रहे हैं, अभी 2 लाख में करके ले आएंगे.
हाँ, मुझे कोई दिक्कत नहीं है. तो मैं तो वेडनेसडे के लिए तैयार हूँ सर. मुझे कोई दिक्कत नहीं. आज बेलिफ, आज ऑर्डर अगर मिल सकता है स्पेशल बेल का तो वेडनेसडे सर. आई एम वेरी हैप्पी.
ऑर्डर तो मिल जाएगा. कब तक हो जाएगा?
हाँ, तो वेडनेसडे सर. वेडनेसडे. I'll make sure that my client is accompanying the person and taking the recurrent accusation.
Wednesday is 10th.
10th.
Okay.
Please, madam. I'll get the necessary application. Obliged.
हाँ जी सर.
બે નંબર સર આપતા. નંબર 2 છે આવતા નથી.
आप एक के लिए हैं?
हाँ, एक માટે.
ये है कहाँ एक?
हाँ सर.
सुबह से आया नहीं.
मैं बाहर बैसे रही सर.
पर बाहर का क्या फायदा, पुकार करने पे नहीं आएगा तो. इसका मतलब पुकार के टाइम तक तो नहीं था. कन्नू सिंह, टाइम पे आने में क्या दिक्कत? हाँ, अभी मैंने कन्नू सिंह बोला, तुम्हें सुनाई दिया? बाहर जब बोला था कन्नू सिंह, तब क्यों नहीं सुनाई दिया? इसीलिए तो पूछ रहा हूं, अगर कन्नू सिंह बोला, बाहर सुनाई क्यों नहीं दिया? जब जब नाम कॉल होते हैं ना, सब कहीं ना कहीं चले जाते हैं, आए होते हैं. अगर मैं 10:30 बैठता था, तुम शायद 10:30 भी आए होते. मैं 11 बजे बैठा हूं, इसलिए तुम 11 बजे आ गए थे. इसके वारंट की रिपोर्ट क्या है? और इसका वो छोटी 22/7.
सर जामीन की कोशिश रख दी और ये 20% पैसा जो जमा किया है उसमें नो ऑब्जेक्शन दिया रिस्पॉन्डेड है.
सर वो इसमें ऐड कर लूं दोबारा?
તરફે બે ગુજરી ગયા છે સાહેબ, એટલે અમને ડેથ સર્ટિફિકેટ સાહેબ અમે નેક્સ્ટ ટાઈમે રજૂ કરી દઈશું જવાબ સાથે. બે નંબર અમે સાહેબ ડેથ સર્ટિફિકેટ રજૂ કરી દઈશું, એટલે સાહેબ એમને પક્ષકાર જોડવા તો જોડે. જી સર.
16/7.
જી સર.
બે નંબર છે એમાં સાહેબ હાઈકોર્ટનો સ્ટે છે ના સ્ટેટસ રજૂ કર્યું છે સાહેબ અત્યારે.
આપી દો. 31/7.
બસ
सीरियल में 23 से ગાર્ડિયન એન્ડ કોન્સેપ્ટની હતી. સાહેબ હું થોડો ટાઈમ જોઈએ છે મારે એક અરજી આપું છું.
सर 2023 से पेंडिंग है।
हाँ बिल्कुल बिल्कुल
सामने किसी ने आके अपोज करना
नहीं,
नहीं,
बिल्कुल ऐसा भी नहीं है.
उसमें भी 3 साल के बाद भी आपको डेट चाहिए फाइल देना।
थोड़ा टाइम सर दे दीजिए. मैं
सर थोड़ा 3 साल हो गए।
नहीं, बिल्कुल बिल्कुल सही बात है. बीच में जो नोटिफिकेशन आया था ना सर, इसमें गार्डियन एंड वो गार्डियन सर्टिफिकेट की जरूरत नहीं है ऐसा मेरे को पता चला था. इसी वजह से ये डिले हो गया है सर. ये इसका वो क्या है इसकी वजह से थोड़ा डिले कर
अगर
दिया,
ऐसा कुछ है तो
वरना मैं कब की जुबान ही दे देता सर इस.
अगर ऐसा आपको पता है कुछ
नहीं
तो
नहीं
करो,
बिल्कुल
देखो।
बिल्कुल नहीं, ये
चला
यहाँ
के
से ही पता चला, डिस्ट्रिक्ट कोर्ट से ही सर. तो थोड़ा कंसीडर कर लीजिए सर इतना. अगर ऐसा लगेगा तो मैं विड्रॉ भी कर लूंगा. ये अगर नोटिफिकेशन की वजह से ये विड्रॉ हो सकता है तो मैं विड्रॉ भी कर लूंगा. 10-15 दिन का सर टाइम चाहिए.
इसमें सामने किसी को पार्टी नहीं बनाया।
नहीं नहीं, सामने कोई है ही नहीं सर. इसमें कोई ओपोज किसी का
सर अपोज ना करे,
नहीं,
सरकार थोड़ी खत्म हो गई।
नोटिस तो पब्लिश करवाई थी.
सरकार थोड़ी खत्म हो गई।
हाँ।
सरकार तो है।
हाँ बिल्कुल बिल्कुल ना,
पार्टी
वो
का
तो एज पर रूल वो क्या है कि कोई भी अर्जी दाखिल होती है तो उसको तो
तो
सब
पार्टी होनी चाहिए ना।
हाँ?
सामावाड़ा होना चाहिए ना। सरकार वो क्यों नहीं बनाते।
कोई सर कोई टेक्निकल इश्यू है तो मैं बनवा दूंगा सर. ऐसा इसमें कोई है नहीं क्योंकि प्राइवेट पार्टी के बीच का मामला है सर ये. ऐसा
कितने दिन चाहिए।
15-20 दिन से.
इसमें भी 15-20 दिन। बेसात लास्ट अपॉर्चुनिटी।
मच होगा.
સિવિલ માં સિરિયલ નંબર 2538 CMA.
જી
હા સાહેબ, એમાં અમે અરજદાર એપેન્ડન્ટ સાથે એમાં સાહેબ સ્પેશિયલ બેલીથી નોટિસ બજાવવા માટે પૈસા ને એવું ભરી દીધું હતું, એટલે સાહેબ બચીને આવ્યું ના આવ્યું.
એમાં નંબર 3 ગુજરી ગયા છે।
નંબર 3 ગુજરી ગયા છે।
અબેટમેન્ટ ઓર્ડર कर देना।
हाँ।
પાછું સરખે કરી આગળ
सर्विस हो गई ना सर्विस। पे तो आया था अभी।
हाँ।
સર્વિસ हो गई ना। સર્વિસ થઈ ગઈ છે
હા।
અને નંબર 3 સામે અપડેટ થઈ ગઈ। સોળ 7 जी सर।
Matter seal number 10 in civil court. It was kickback for the advocate to appear on behalf of appellants. That they
Number?
have appeared and respond number serial number 10 CMA.
It's not 10 sir।
11 sir.
Ten is MSCP।
29 so 20 हाँ CMA 3926. I am for respond number 1. I have filed my reply
10th of June।
10th of. They are tendering an application for service to the respond number 2-1 to 2-5.
by special bailiff।
Yes. I live.
Day after tomorrow।
I live.
डब्ल्यू साइन
जी, समाधान हुआ इसमें?
नहीं, बात चल रही है सर। और सीरियल में 19-20 सर।
प्रणय में 16-7।
સર સિરિયલ નંબર 19 અને 20 માં સર નંબર 3 પર વીસી ફાઇલ કરી છે બંને હા નંબર 3
એમાં નંબર 2 ગુજરી ગયા છે.
देख लेते हो।
સર સિરિયલ નંબર 15 એમાં સર નંબર 2 તરફથી ડિલીટ અરજી આપે છે.
कॉपी दे दी?
જી સર સર એમાં આજે ઓર્ડર કરી દેજો ને.
वो आ तो जाए.
જી સર
एप्लीकेंट को तो बुलाओ.
જી સર
ઓર્ડર માટે છે.
अभी नहीं हुआ इसमें टाइप.
સિરિયલ નંબર 11 માં તો અરજદારના પૂરા પડ્યો સામાવાળાનો.
हाँ, उसमें उन्होंने डेट ली है.
જી સર.
23/6 लास्ट अपॉर्चुनिटी.
मैं मेंशन
हाँ जी.
सीरियल नंबर 22 है सर सिविल बोर्ड
22?
हाँ सीए में 31
जी.
मैं उसको સામાવાળા એક તરફે જો વાદી આંક 5 નામંજૂર થયો એના ઉપર અપીલ કરેલી ડિલે સાથે સર. એકચ્યુઅલી સાહેબ એવું છે રેકર્ડની પરિસ્થિતિ એવી છે કે આંક 5 મંજૂર થયો આંક 5 નામંજૂર થયો દિવસે ઓનલાઈન બોર્ડ પર ચડી ગયો હતો પછી મેં 50 દિવસ બાદ ડિલે દાખલ કર્યો. હાલમાં સાહેબ ટ્રાયલ કોર્ટની પરિસ્થિતિ એવી છે કે ત્યાં ઇસ્યુ ફ્રેમ થઈ ગયા છે તપાસ હજુ થઈ ગઈ છે મારે મેં ઉલટ તપાસ બી લઈ લીધી છે અને વાદીને પુરાવા વધુ પુરાવા માટે છે. આ પરિસ્થિતિ છે સાહેબ.
1/7 તારીખ છે.
હા સર હવે મને પૂરા નકલ મળી નથી સાહેબ એટલે મેં જવાબ નથી આપેલા સાહેબને રેકર્ડ પરની બાબત છે એટલે સોરી
જવાબની જરૂરત નથી હવે.
હા એટલે જવાબની સાહેબ ના આવતો સાહેબ ઉપર મોકલ્યો મેરિટ પછી ઓર્ડર થાય કારણ કે સાહેબ ત્યાં ઉલટ તપાસ થઈ ગઈ મારી તો પ્રતિવાદીને એમના વાદીના વધુ પુરાવા માટે છે.
1/7 જોઈ લઈએ. મેડિકલ સર્ટિફિકેટ માટે છે.
હા એમના મેડિકલ સર્ટિફિકેટ માટે હશે કદાચ બસ ઓનલાઈન હવે તો કયો આજનો ઓનલાઈન ઓર્ડર સાંજે જ અપડેટ થઈ જાય છે એટલે ડેટ ઓફ નોલેજ કે જે દિવસે ઓર્ડર થાય તે રીતે જ જાણ છે સાહેબ એમને સમજો તે કરીને તો ઇસ્યુ ફ્રેમ થઈ ગયા પુરાવા રજૂ થઈ ગયા મેં ઉલટ તપાસ લઈ લીધી વધુ પુરાવા માટે છે વધુ પુરાવા 3-4 મુદ્દત પડી ગઈ છે.
1/7 ઓર્ડર કરી દઈશ.
કઈ વાંધો સર થેન્ક યુ સર.
અમારા આર્ગ્યુમેન્ટ પૂરા થઈ ગયા હતા, અધર સાઇડના આર્ગ્યુમેન્ટ. એટલે પછી જ serial number sir. Serial number 30 unit.
26
हाँ 26
जी दलील
મારા આર્ગ્યુમેન્ટ તો ઓવર થઈ ગયા છે સાહેબ, પણ અધર સાઇડના આર્ગ્યુમેન્ટ માટે હતું. હવે છે નહીં ને અહીંયા ટ્રાન્સફર થઈને આવ્યું છે, એટલે મારે કદાચ ફરીથી કરવાના થાય.
अभी तो दोबारा ही करना पड़ेगा.
હા તો ઓલરેડી આઈ હેવ ગિવન रिटर्न आर्गुमेंट यू ऑनर.
ओरल कर दीजिए, रिटर्न भी देख लेते हैं.
हाँ तो ठीक है, नेक्स्ट टाइम कर देता हूँ.
आज नहीं.
नहीं सर, अब फिर से आई एम अंडर इम्प्रेशन कि मेरे तो आर्ग्यूमेंट कंप्लीट हो गए, देयरफॉर अब मुझे भी पढ़ना पड़ेगा पूरा.
13/7
प्लीज जाना, I'm obliged जाना. TMDC 16/22. બસ હવે હું અરજદાર તરફે છું. અગાઉ મેં વારસો જોડવા માટેની અરજી આપેલી છે, એમાં એ હાજર થઈ એમને બચી ગયું છે, એમને મેં જવાબનો હક ભંગ કરવા માટેની લાસ્ટ અરજી આપેલી, જે અગાઉ નામદા કોર્ટમાં હતી ને ત્યાં માટે.
इसमें पहले कोई और आया था ना? पहले कोई और आया था आपकी जगह?
क्या सर?
कोई और एडवोकेट आए थे अभी पहले?
नहीं सर, अभी तो कोई नहीं आया. सामने वाले आए हो पता नहीं सर.
इसमें डेथ हुई है एक.
हाँ डेथ हुई है ना सर, उनको मैंने जोड़ा है.
कब हुई थी?
हाँ?
कब हुई थी डेथ?
वो तो काफी टाइम पहले हुई थी, पर उन्होंने नेक्स्ट मुद्दे उसके अगाउ अगाउ जब हियरिंग था ना, उस टाइम ही उन्होंने वो किया था।
डेथ 2022 में हुई,
हम्म।
आप 2025 में एप्लीकेशन फाइल कर रहे हैं।
नहीं सर, 22 में एप्लीकेशन फाइल की है मैंने।
22 में कहाँ की है? ऑर्डर 22 नहीं सर, 2022 कह रहा हूँ।
हाँ
2025 में आपने ये फाइल किया ना लीगल
हाँ।
एड्स की एप्लीकेशन,
जी जी सर।
3 वर्ष પછી।
पर सर उन्होंने वही तभी तो जाहिर जाहिर किया है उन लोगों ने।
सर उन्होंने कभी भी जाहिर किया हो, अबेटमेंट तो हो गई।
पर सर वो लोग वीपी फाइल करेंगे और उसके बाद वो जाहिर नहीं करेंगे, हमें कैसे पता चलेगा कि उनके कितने हैं वारसदार?
सर मैं आप क्या बताऊं, क्योंकि मैंने तो यही लॉ पढ़ा है कि 9 दिन पूरे होते ही अबेटमेंट हो गई।
जी सर।
3 साल के बाद आप क्या एप्लीकेशन दे रहे हैं? एक ही एप्लीकेशन ना बस, एक लीगल एयर की।
हमारा होगा नहीं।
हम्म।
5 की डेथ 2022 में, दिखाना की एप्लीकेशन।
3/7/2022 से गुजरी।
3/7/22 से गुजरी गया साहब, हमने जाहिर जमा करा है लास्ट। आर के ठाकुर होते, आर के ठाकुर होते इस सीनियर जीसी ठाकुर।
सर आपकी जो मेन ये सीएमए है डिले कंडोनेशन अर्जी, ये नंबर 5 के अगेंस्ट अवेट हो गई। अभी क्या करना है आपको?
ऐसा हो तो मैं एक मुद्दत अर्जी आपको बता रहा था,
किस लिए?
उसके डिले हो गया सर, सीनियर से एक बार बात कर लेता हूँ मैं आपकी।
सीनियर कहाँ है?
सर तो अहमदाबाद है सर।
सर उन्हें आना चाहिए ना, अभी तो वेकेशन का बहाना भी नहीं चलेगा आज से तो।
नहीं नहीं मैं कहाँ वैकेशन का बोल रहा हूँ सर, जो सच है वही मैं बता रहा हूँ सर आपको।
कल बुला लीजिए।
मैं एक बार बात करूँ सर।
कर लीजिए।
सीरियल नंबर 7
सिविल क्रिमिनल
क्रिमिनल
5825।
હા
हाँ।
સર એમાં ડી લિસ્ટ માટે હતું, અમે આરોપી તરફી છે।
आरोपी कहाँ है?
સર એક્ઝામ્પશન અરજી આપું છું।
ये कौन सा टाइम है मैडम एग्जाम्पशन का? मुझे आरोपियों के लिए भी शाम तक वेट करनी है ताकि शायद कोई आ जाए एग्जाम्पशन अर्जी लेकर। बताइए, आरोपियों के लिए भी कोर्ट बैठी रहे शाम तक।
પહેલા એ આવવાના હતા પણ ના એટલે મારે એક્ઝામ્શન આપવી પડે.
लाइए रिजेक्ट करता हूँ. क्या रीजन है? रिजेक्ट. रिजेक्ट एनबीडब्ल्यू. और इसमें क्या डिलीट बाकी है? रेविस साहब. वो नंबर लिख दिया ना? ये जो नंबर था एड्रेस में, पहले नंबर नहीं था ना, जो मेन केस में इन्होंने नंबर नहीं लिखा हुआ एड्रेस में, सीधा वो जगह लिखी हुई थी कौन सी लड़की.
घर नंबर लिख दिया 101.
जी ब्लॉक्स. हाँ बस फर्स्ट नहीं ले
101.
आमा 103 आपका ये बी ब्लॉक
जी ब्लॉक.
राइट थे.
हाँ.
आपको ठीक जो जाएंगे ना साथ में वो जानते ही है प्रॉपर तो उनको आप ट्रेन करेंगे.
हाँ लेंगे. हाँ जी. वो पार्टी है?
नहीं पार्टी नहीं से
फिर कैसे करूं?
सैलरी हुआ ना ये फाइल करने के बाद.
पार्टी नहीं है तो उसको कैसे करूं नोटिस?
आपने लास्ट टाइम ऐसा बोला था उन लोगों को कि भाई आप एप्लीकेशन करो ज्वाइनिंग करने के लिए लेकिन
पर वो-
उन्होंने की नहीं है.
जब तक ज्वाइन ना हो तब तक कैसे करूं?
Yes, yes.
हाँ जी पूछ लिया.
नेक्स्ट वीक पॉसिबल रिक्वेस्ट इज नेक्स्ट वीक 17 जून.
नेक्स्ट वीक क्यों?
तो क्लियर कर देंगे सर जो भी होगा.
हाँ
जो भी होगा वो क्लियर कर देंगे सर उसका 17 जून.
ठीक है 15.
हाँ सर रिक्वेस्ट 17 15 को
अभी नेक्स्ट वीक कह रहे हैं आप.
सब सीनियर नहीं है 15 को इसलिए मैं 17 बोला सर.
आप कल आ जाएं फिर.
सब 14 कर दीजिए कोई बात नहीं.
सर आपको केस तो चलाना नहीं.
नहीं सर चलाना है इसलिए मैं क्या मना कर रहा हूँ
14 को मैं नहीं आ सकूंगा सर, संडे है.
सर. तो 12 कर दीजिए कोई बात नहीं 12 भी चलेगा सर.
26 नहीं सॉरी 21 में बात
ठीक।
श्योर.
ऑब्वियस सर.
हाँ जी. हाँ जी.
सिविल में सीरियल मत तो 1870 आरसी.
जी आप किसके लिए?
एपेलेंट आर पटेल.
दलील
दलित आई दिल्ली से बंदी नहीं लेकिन
ओरल
ઓરલ થઈ ગઈ હતી એમાં એમને મારે તો ઓરલમાં એવું છે કે નવી શરતની જગ્યા હું પાવર ઓફ એટર્ની કરેલી છે.
बस इतनी सी दलील है,
भाई
कोई फैक्ट्स नहीं है, कुछ नहीं है.
वो नहीं जुबानी में ऐसा ही आया कि नवी शरत की जुबानी.
सर जुबानी में आया, कुछ बताओगे तो सही, कुछ फैक्ट्स तो
हाँ।
दोगे. दलील एक लाइन में
हाँ,
दलील बस.
क्या लेखी दलील में कर दे दो इसका 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 सीपीसी सीपीसी का सीपीसी बयान रूल
ઓર્ડર છે કે એએચ પટેલનું અને એ એમને બી લેખિત આપી દીધી, મેં બી આપી દીધી પુરોહિત સાહેબનું, એમાં બંનેની લેખિત કરી દીધી,
मौखिक नहीं करनी है अभी?
નહીં કરને की।
लिख दो मौखिक नहीं करनी। वहां की थी पुरोहित साहब के पास, अब नहीं करनी। ठीक है सर, ये एच पटेल साहब भी आ जाए, फिर करता हूँ।
ઓલ્ડ જૂની છે પછી એમાં ક્યાં લખે
है जी?
ઓલ્ડ है कभी।
ओल्ड है तो सर करके खत्म करो ना। दे दो 15 साल।
सीरियल नंबर 9 CME प्रॉपर एप्लीकेशन।
जी। और
सीरियल नंबर 12 223/25।
सर्विस बाकी है।
सर्विस मैं अभी सर देख लेता हूँ, क्योंकि इसमें कॉम्प्रोमाइज के लिए बात चल रही थी, लेकिन डिफेंस आया गया लाइसेंस का, ये कॉम्प्रोमाइज नहीं होने वाला अभी। तो मैं वो नंबर 1 का और देख लेता हूँ, नोटिस गांधीनगर का ही है, सर हो गई कि नहीं हो गई।
नहीं हुई।
નથી तुम्हारा काम आप શું જોઈ લો। सीरियल नंबर 13 और 14 नंबर 1 का रिप्लाई आ गया है, नंबर 2 का रिप्लाई के लिए, और ये शायद परीक्षा है, तो कॉम्प्रोमाइज में इसमें भी डिस्कशन हो गया है।
15/7 रखी है।
सीरियल नंबर 15
डिलीट एप्लीकेशन है ये।
हाँ, उनकी डिलीट एप्लीकेशन आई है, और मेरे पक्ष का जोड़ने के लिए एप्लीकेशन में दे रहा हूँ। थर्ड पार्टी क्लेम जो है वो वेगमा में है। મેં એફકો ટોકીને જોડી લીધી, એટલે એફકો ટોકી વાળાએ કીધું કે ભાઈ મારો વીમો ખાલી ઓડીનો છે, થર્ડ પાર્ટી મેગમામાં है।
दोनों एप्लीकेशन पे ऑर्डर कर लेंगे। दोनों एप्लीकेशन पे ऑर्डर डिलीट, उसमें डिलीट और उसमें। हाँ जी।
सीरियल नंबर 16 उसमें सर पूछताछ आ गई है मेरे पास, तो वो शनिवार के डेट में तारीख दे दो, तो मैं उस टाइम पे बुला लूंगा। हाँ 18/24
11/7
उसके पहले नहीं होगा सर, ये
लोक अदालत में कर
18/6
देते हैं ना।
18/6 को
लोक अदालत में कर देते हैं।
नहीं 18/6 को क्लाइंट को बुला लूँ मैं, तो पूछताछ फाइल हो जाए।
अच्छा
पूछताछ मेरे पास आ गई है।
ठीक है 18/6 को।
हम्म એટલે પૂછતાછ ફાઇલ થઈ જાય ને પછી મારે એક વાંધો નહીં લોક અદાલતમાં। सीरियल नंबर 17 इसमें कॉम्प्रोमाइज की सर बात चल रही है, लेकिन नोटिस सर हुआ कि नहीं वो देख लेता हूँ।
नोटिस
नंबर
तो हो
1
गया।
और 2 का बने नहीं गई है।
एक अने बे बने।
हाँ, तो इसमें भी सर कॉम्प्रोमाइज की बात चल रही है ICICI कंपनी। जी सर। वो सुधारो પછી કરીએ આજે મેગા પ્લાન ડિલીટ કરવા में नो ऑब्जेक्शन લખી દીધું છે।
जी आप किसमें?
सीरियल नंबर 34 MC है।
बाकी 6 હવે
जजमेंट માટે
બાકી 6 હવે।
હા
ઓર્ડર થાય નામદાર કોર્ટને યોગ્ય લાગે સાહેબ order.
ठीक है रिजेक्ट कर देते।
કારણ કે સાહેબ મેં 2024 માં સાહેબ અપીલ કરી, અપીલના સમયે સાહેબ બજાવણી થઈ પછી મને ખબર પડી સાહેબ એ રાશે ઓઢવ ખાતે સાહેબ એટલા માટે અને મને બજાવણી થયાની
सर
ખબર
मैंने आपको कहा था किसी सीनियर से एक बार कंसल्ट कर लें Just 1 minute, sir. Let me have the file.
Serial number 4 છે. Civil appeal 2 of 19.
Yes, sir.
Yes.
So your main contention was preemption.
One preemption and bar of statute regarding fragmentation act. That when the particular transaction is prevented or there is inhibition of doing a particular thing without permission, in that eventuality, it goes contrary to the object of section 23 of the Contract Act, and therefore that transaction being opposed to public policy, anything done in contravention of the statutory provision whereby the transaction is prohibited or can be permitted only there is a consent or permission, previous permission from the competent authority. In such case, such a transaction will be of no consequence. One of the suit was filed in relation to the land in question. Land is survey number 889/1. Only hurriedly I will just go through 889/1 and 889/2. Out of that, with regard to 889/1, the defendant number 1, Keshavlal Somabai, who was my uncle, real uncle, had executed a stamp gift deed, which I said that cannot be regarded as a valid gift deed, though the trial court has said so. That I will come to later. In favor of number 2, undivided share, the property is admittedly undivided. The evidence conclusively shows that the land is undivided land. There has not been any partition. The defendant number 2 has also admitted. And the suit is filed by Babar Bhai's son, Babar Bhai and Keshavlal. They were true brothers. Babar Bhai Somabai and Keshavlal Somabai. Somabai's branch fellow.
You were the plaintiff.
Yes. I was the plaintiff. Anil Kumar Babar Bhai was the plaintiff, the son, one of the co-owner.
So, D1 and Babar Bhai, they were brothers.
D1 and Babar Bhai were real brothers. And they inherited a ancestral agricultural land, which was admittedly undivided. Now, D1 sold his half share to the defendant number 2. And therefore,
sold or gift?
No, he sold.
Okay.
It was my case that D1 had also executed a stamped document on stamp of ₹3, and that was a gift deed prior to some 35 years. So based on that, the trial court said that gift deed is valid.
Gift in favor of?
gift in favor of Malhotra Babar Bhai. The brother, defendant number 1, executed a gift deed, Exhibit 48. But that was unregistered gift deed, Manoj. So, I mean, I had made it clear that in all fairness to the court as well as respecting the law as it stands, that gift deed is not a legal gift deed. The trial court, Malord, held that whether it is a undivided land and ancestral land, issue number 1, answer is affirmative. Issue number 2 was whether the plaintiff proves that defendant number 1 has sold, had gifted the property to plaintiff's father, as I said, to Babar Bhai, to which also the learned judge said that yes, because it's a document prior to 30 years. So I must get it declared as valid declaration under section 90 of the Evidence Act, regarding presumption as to validity. But that issue is decided in partly affirmative by holding that there is a gift deed, valid gift deed, and partly in negative by holding that there are other co-owners and therefore one co-owner cannot file a suit. So it was like this. And third is also consequential. વાદીના દાવાને જરૂરી પક્ષકારો નહીં જોડવાનો બાદ છે. Non-joinder of necessary parties. That was also decided only on that count. That yes, only one co-owner, co-sharer has filed the suit against the third party, stranger. Now, so far as issue number 2 is concerned, I have made my position clear that that's an incorrect finding of the learned judge, because there is also a cross objections filed by my learned friend under order 4122. And with regarding this, that a unregistered gift deed cannot be regarded as a valid thing, and that has been so held. So regarding issue number 2, the findings are apparently wrong. But the second finding that only one co-owner cannot file a suit, that is incorrect. That my learned friend also last time gave concession that yes, fairly have said that co-owner has a right to file a suit against a stranger. So the issue number 3, what has been decided in affirmative, requires to be set aside. Then issue number 4, whether it is time barred, answer is no. Issue number 5 was માગ્યા મુજબની જાહેરાત મને હુકમ મેળવવાની દાદ મેળવવા હકદાર છે. The court said suit not maintainable by only one co-owner, therefore I am not granting the prayers for it. Issue number 7, શું એવું સાબિત થાય છે કે પ્રતિવાદી નંબર 2 ની તરફેણમાં થયેલ દસ્તાવેજ જે તે પ્રવર્તમાન કાયદા મુજબ થઈ શકે નહીં ને રદબાતલ છે. So that was the transaction which was clearly hit by section 23 for 2 violations, broadly speaking, under section 22 of the Hindu Succession Act, and secondly under
So even issue number 7 was in your favor.
Yes, it has been decided in my favor.
Only the ground is
that one co-owner cannot file, one co-sharer cannot file.
That is the main ground on which the suit has been
Yes,
dismissed.
on the last occasion, my learned friend agreed proposition.
So that is the case.
I had submitted and I again submit that the London trial judge was wrong in holding that. So far as that issue is concerned, he was wrong. But all other issues which were required to be decided in my favor had been wrongly decided by learned judge against me, and therefore I have filed the cross objections also. So I would like to argue on all those points that all these issues were required to be decided in my favor, and that the only issue that the learned judge decided rightly was dismissal of this
Issue number 6.
Yes, sir.
શું હુકમ અને હુકમ
Yes, Your Honor.
Now,
So if you agree that the finding that a co-sharer, co-owner cannot file the suit, to that extent you agree?
Co-sharer can file.
Can
suit.
file.
suit.
So,
He can
to
file
that
suit.
extent that the judgment is wrong,
Yes,
you agree?
yes, Your Honor.
So
Co-sharer
now,
can file.
whether you want me to decide all these issues or both of you want that?
No, I want
after-
this honorable court to decide these issues.
Okay, not to
Because,
remand back.
because the record is with this honorable court.
It is there.
And
But
everything is
if
on
the
record.
judgment is set aside on this ground, and then the trial court is asked to decide afresh.
I would not agree with, and ultimately it is your honor's power. But
No,
I would
I'm
like
not
to-
on that
Huh.
powers. I'm just asking
no,
both
no,
of you.
no, I'm not agreeable to that.
Okay.
I will argue out the matter and I will try to satisfy this honorable court that this honorable court may decide the matter afresh, of course, in as much as everything is on record. Everything can be
No,
decided.
no doubt I can.
Yes,
There is no doubt in that.
yes, sir.
I can decide. Yes, sir. Please
The
continue.
controversy in cross objections are only limited to these facts, as a matter of fact, as I said so, that the court has decided wrongly that there is a oral gift deed. I mean, oral gift deed or gift deed, which is unregistered one. And the trial court said that that's a legal document. So cross objection is in relation to that. And the
Which my friend agrees.
Yes, yes,
yes,
yes.
yes. I have also
It is
agreed, and you have also said, and the trial court said that one co-sharer cannot file a suit. So that my learned friend has agreed. So these are the basic things. Thereafter, now,
So
may I
legal
request
position
my
is
lord?
clear. Both of you agree on that.
Yes,
Now only the factual position remains.
factual positions are to be seen. My lord. Grateful to my lord. My lord, the honorable, because in view of the subsequent development of facts, that the land in question was subjected to town planning scheme. Some other final plot is given, not the original one. Part of the original is also maintained, and rest is altogether a new land. The final plot possession is already given to us, the sons of Babar Bhai. I have produced all those documents. My lord, on that basis, the honorable court allowed me to amend the grounds of appeal that has been carried out. My additional evidence application is also there, exhibit 42. Last time some exhibit dispute was there that whether
that
it
is
is
also pending.
separately exhibited or not. It is now exhibited separately.
Then first order should be passed on that.
My lord, the legal position is this, my lord, with highest respect to the honorable court, that on the last occasion also, the honorable court asked my learned friend that with regard to this additional evidence, the court is inclined to allow because they are the subsequent facts, subsequent developments during the pendency of the suit, which has a direct bearing to the matter. But at that time, it was found that since I have produced the additional evidence application in the form of the Honorable High Court style, whereby I produced the index, that first the application and then the other documents. The two things have been separated and it has been now given exhibit 42.
With due respect to my friend, I would like to submit that the court did not express any opinion.
No, the court.
No.
You said,
I had submitted that I will argue on that point.
yes, you will
And-
argue on
and-
that point,
and
but the
that-
court-
No.
Court expressed.
No. Court did not express any opinion. It was only-
તેને 42 આપી દીધો.
The only correction that I would like to make
હા,
is
એડવાન્સમાં આપી દીધો.
that this honorable court had at that point of time decided that then let us first of all decide this application. And we both have the opinion that this can be decided along with the appeal.
I have passed the order to be heard along with exhibit 1.
Right, sir. Right,
Correct.
sir.
But
Right.
say, if this application is allowed, then what?
We will argue.
Then I cannot.
We both
then
will
then I cannot decide on the main this appeal.
Yes.
No, sir.
Yes,
Sir,
it
my
will be
submission would
pending
be,
and then
my
matter to be
submission would
remanded on some issues, Manoj, 1 and 2.
But what are the documents that you want to prove?
Yes, Manoj. Kindly see
I will
those
argue
documents.
on that also, Your Honor, that it cannot be looked into, that I will argue. And even if ultimately this honorable court allows, after my arguments, then also I will submit that that would not help the appellant in any other manner. And appeal is liable to be dismissed even after, assuming for the sake of argument that is allowed. That also I will argue.
Whether these documents are in dispute?
No. That was
These
also
are
asked
official
by the
documents, I think.
I plead ignorance about those documents, Your Honor. I plead ignorance. I will not submit whether they are genuine, whether they are not genuine, because I do not have any knowledge about it. That was not the
No,
subject matter.
But you can inquire about that, sir.
No, I do not
Document
want to
are not
That
inquire.
will cut short the.
According to me, Your Honor, these I will try to satisfy this honorable court that according to me, these documents are totally irrelevant. They cannot be looked into, and I will try to satisfy Your Honor. Ultimately, if the honorable court asks me that you verify, I will have to verify. But
No, it is not, sir. There is no directions regarding
no,
that.
no. Your Honor can always even direct us, because ultimately, if in the interest of justice, this honorable court directs us, then we are bound to do that. But as I understand, they are all totally irrelevant, and I will try to satisfy on that.
So then let us first decide this application.
Yes. Well, the law on the point is, Malhotra, that it has to be heard together, and we are hearing it together. We are hearing it together. If your lordship permit, I may first read the trial court's relevant paragraph, and then we will go to this document. Regarding 8.1, the basic facts that the suit premises was originally belonged to his grandfather, that is Somabai Girdharbai. But after his death, the land came in the share of Babarbai and Keshabai Somabai. And 8.1, the last line below of that para of the trial court. Am I with my notes?
Yes.
Yes. According to this witness, the plaintiff has his undivided share in the suit land, and he used to make agricultural work, thereby having peaceful and actual possession over the suit land. The witness personally knows that defendant number 1 has donated suit land in favor of plaintiff's father. We are not giving any importance to this sentence. Defendant number 2, the third party purchaser, has tendered his examination in chief exhibit 63 and affirmed the facts which has stated in the evidence. If we refer entire examination in chief, defendant number 2 has reiterated all the material facts of his reply filed while exhibit 27, and therefore, for the sake of convenience, the contents of it are not reproduced here. However, sum and substance of it have been considered by this court. Paragraph 10. The learned advocate of both the sides have cross-examined both the parties along with the witness. Now, if we read and refer to the cross-examination of defendant number 2, while exhibit 63, the defendant has clearly stated that the suit land is undivided land, and no division of it have been made till today. This means that the suit land has not been divided amongst the co-owners of the suit land. It is also admitted by this defendant that on the date of execution and registration of sale deed exhibit 67, there was no clarification came to be made that out of such suit land, which portion of the suit land belonged to defendant number 1 and which portion belonged to Babarbai Somabai, father of the plaintiff. So far as whether the suit land is ancestral property or not is concerned, the plaintiff has in his examination in chief exhibit 46 clearly stated that the suit land belonged to his grandfather, Somabai. But after his death, same came in the joint share of Babarbai and defendant number 1. The learned advocate for the defendant has clearly admitted during his cross-examination that not learned advocate, it is the witness of defendant, yes, that the suit land belonged to the plaintiff's grandfather, Somabai Girdharbai. Now, considering the admission coming on behalf of defendant, the suit land is established to be ancestral land, and therefore it is proved that the suit land belonged to father of the plaintiff and defendant number 1 as successor of their father, that is Somabai Girdharbai. This fact is well established by village form number 7 and 12 produced at record exhibit 53. Moreover, the change entry number 5924 produced on record by exhibit 54 also clearly show that the suit land belonged to defendant number 1 and Babarbai Somabai. Thus, as defendant number 1 had voluntarily donated, this is to be bracketed, I would say, land in favor of Babarbai Somabai, such entry came to be made on so and so. It is pertinent to note here that the name of Babarbai Somabai has included in the suit land by virtue of change entry number so and so mutated in the village form number thus. The suit land again proved to be ancestral property of defendant number 1 and Babarbai Somabai, who happen to be real brothers of each other. The witness of plaintiff clearly stated in his cross-examination 58 that there are 4 sons of his grandfather Somabai Girdharbai, out of which Adar Bhai and defendant number 1 has no child, while other 2 sons have children. The witness of the plaintiff has also admitted that the share from the property of Soma Bhai Girdhar Bhai was given to the family of this witness, while the property of defendant number 1 came to the share of Babar Bhai Soma Bhai. That is on the basis of the gift deed. Therefore, also it is the case of on record that the suit land is joint property of the Babar Bhai Soma Bhai and defendant number 1. As admitted by defendant herein above, the suit land is proved to be undivided land, and hence he answered the issue number 1 given in affirmative. Then para 11. This is touching section 22 of the Succession Act. It is the evidence of the defendant that he purchased the suit land from defendant number 1. This is evidence of defendant number 2. That he purchased the property from defendant number 1 on 24/7/1995 by virtue of registered sale deed. The sale deed is produced and recorded by defendant white so and so, exhibit 67. Now it is settled law that if any immovable property belonging to 2 or more co-owners, then in that case, before execution of any agreement regarding sale deed of such property, the signature and or permission of other co-owners is undoubtedly requires to be obtained. Here it would be worthwhile to refer to the judgment rendered by Honorable Supreme Court in the case of Ramdas so and so so and so. When any immovable property belong to 2 or more co-sharers, then in that case, for execution of an agreement to sell, the signature of all co-sharers are required to be obtained. Now, this judgment as such is not applicable. There is another judgment in the case of Baburam versus Santokh Singh, 2019-14 SCC. I can give it to the Honorable Court for that purpose. We will refer to that, where the Honorable Apex Court has said that what is the statutory
Probably
implication.
this judgment seems to be in the case where the whole of the property is sold.
Exactly, madam. Exactly. So this is not applicable. What is applicable is, my lord, I have produced, I will be showing it to the Honorable Court, my lord, in the case of Baburam versus Santokh Singh. Clear case in relation to agricultural land itself. And here also it is admitted position that which portion is to be given. The defendant number 2 also says that that is not certain. It was undivided. That is also admitted. But sale deed says that Uttar taraf na Dakshin taraf na bhag. How it can be said? So sale deed is also bad on that count also by making false statements. Then such agreement to sell would not be held enforceable. Honorable Apex Court has further said that only one co-sharer has no absolute right property in question, and he cannot confer any right whatsoever upon plaintiff for grant of degree for specific performance so and so. Now, in the present case on hand, the suit land belonged to father of the plaintiff, Babar Bhai. This means that defendant number 1 has got no absolute right to sell the suit land in favor of defendant number 2. Moreover, the suit land is admittedly undivided land, and therefore also defendant number 1 has got no any independent right to confer any right to defendant number 2. Therefore, the sale deed produced on record while exhibit 67 has got no absolute legality, because defendant number 1 had got no absolute right to sell out any portion of the suit land to defendant number 2, and therefore the sale deed 67 requires to be cancelled even on this count too. The defendant number 2 has clearly admitted in his cross-examination exhibit 63 that defendant number 1 had 3 brothers, and at the time of execution of registration of sale deed at exhibit 67, he was knowing the fact that defendant number 1 is not exclusive owner of the suit land. This means that it was within the knowledge of defendant number 2 that along with defendant number 1, there are other 3 real brothers of him. But even then, defendant number 1 had, without obtaining signature or permission or consent of 3 brothers, executed sale deed by exhibit 67 with respect to the suit land. Above referred judgment referred by Honorable applies to the present case. As a matter of fact, section 22 Hindu Succession Act clearly deals with this one. Of him who had given equal right over the suit land, whose signatures had not been obtained, and therefore the sale deed at exhibit 67 is proved to be not enforceable by law. The defendant number 2 has also admitted his cross-examination that after knowing the fact that defendant number 1 had executed gift deed in favor of somebody else with respect to the suit land, he approached defendant number 1 for cancellation of such sale deed. This is only a matter of facts, which the defendant number 2 said that he came to know that defendant number 1 had executed a sale deed in favor of Babar Bhai, and they went to them for cancellation of that document. But it is hardly of any consequence, because that gift deed is of no consequence. This fact unfold the untold truth that even the defendant number 2 was also ready to cancel. Even defendant number 2 was ready to cancel his own sale deed at Exhibit 67 after knowing that entire suit land is gifted to father of Babar Bhai. Thereafter, the legal position, as I told to the Honorable Court. Then para 12.2. The defendant number 2 has further admitted during the cross-examination by Exhibit 63 that Malhotra had held that sale deed Exhibit 67 was made with a breach of Fragmentation Act. The defendant number 2 has also admitted that even in appeal, the collector has also held that the sale deed Exhibit 67 is a breach of Fragmentation Act. The defendant has also admitted in the appeal against the order of the collector. The concerned authority had also held that the sale deed Exhibit 67 was a complete breach of Fragmentation Act. So, a document in violation of the Fragmentation Act, Section 23 Contract Act. The plaintiff side has produced relevant order of Revenue Authority Exhibit so and so to so and so. Now, if we refer to these orders, this clearly seems that the Revenue Authority has not only cancelled the change entry made in favor of defendant number 2, but also observed that by such sale deed Exhibit so and so, breach of provisions of Fragmentation Act is also committed. Now, if the sale deed Exhibit so and so is executed in breach of the provisions of Fragmentation Act, the same cannot be said to be legal and genuine, and therefore it is held that the sale deed so and so is not enforceable by law, though that specific provision of Section 23 is not mentioned. The essence of the principle is mentioned, is not enforceable by law, even on this count too, and therefore issue number 7 is answered in affirmative. Now, paragraph 13 is in relation to that oral, not oral, that inchoate unregistered gift deed. So that is of no consequence, though the learned judge has believed that it is so. So 13, 14, 15 not to be considered at all. Then 15.1. In 15, on internal page 19, last two lines. Therefore, neither Babar Bhai nor his two sons Vijay Bhai, Yogesh Bhai have been joined in this suit proceedings, because of which the suit is authentically barred by principle of non-joinder of necessary parties, and hence I answer issue number 3, affirmative, that the suit is barred by non-joinder of necessary parties. So that I have already argued. 15.1, again, so far as issue number 5 is concerned, plaintiff has proved his case, but the suit of the plaintiff is authentically seems to be barred by principle of non-joinder of necessary parties. Therefore, the suit is required to be dismissed on this ground. The authority relied upon by the defendant so and so applied to the present case. Now, in cases of suit for partition, all sharers are required to be joined, but this is not a suit for partition. So that was the decision in relation to is applied to the present case on hand, because plaintiff has not joined necessary party, because of which the suit shall have to be dismissed. Para 16 is again, my lord, with regard to the gift on a stamp paper of ₹3. Defendant failed to establish that which is the adequate amount, whether the land was valued more than 100 or not. My lord, it's a 8,000 square meters of land, so one cannot even assume. Then so the conclusions of the answers which have been given to the issues are on these lines, that issue number 2 have said affirmative regarding that gift deed, Exhibit 48. So Exhibit 48 can be declared as not legal since it is unregistered gift deed of immovable property. But at the same time, the second portion of it, that વાદી વારસાઈ હકે દાવાળી મિલકતના કુલ સ્વતંત્ર માલિક કબજેદાર થયા છે, કુલ સ્વતંત્ર માલિક નથી થયા. He is only a co-owner, co-sharer of the property. and issue number 3 regarding non-joinder of necessary parties. So this is in sum and substance. The court did come to the conclusion that the transaction in question is illegal for 2 counts. One, section 22, other is about section 23 of the Contract Act. Now, this stage, if I am permitted to point out few of the relevant judgments on the issue. How the provisions of section 23 of the Contract Act is affected. Very interesting facts of that case. Yes. So first, I will like to read section 23. Honorable Apex Court also considered the same. When any act is prohibited, that without obtaining specific consent or specific permission from competent authority, you shall not transfer the property. Then such prohibition coupled with the penalty that if you do this, this will happen. So in such a eventuality, such transaction itself will be regarded as void. There are cases where it is voidable. The Apex Court has discussed all these facts, but section 23 reading first. Consider what consideration and objects are lawful and what not. The consideration or object of an agreement is lawful unless it is forbidden by law. One is first clause is forbidden by law, or if such a nature that if permitted, it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it immoral or opposed to public policy. In each of such cases, the consideration or object of the agreement is said to be unlawful. Even if some money is paid, consideration is paid, the court will say, the statute says that in each of these cases, consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. So section 23 is on the clear-cut voidness of a document. Now, this judgment 2021, I have given the copy to my learned friend. The exposition of law, first we will go to paragraph 14. It was a case, my lord, where the foreign exchange regulatory law, it says that a foreigner or who is holding less than 40% share in any property in India, or who is not a citizen, he cannot acquire any property, hold any property, or transfer any property without the permission of the competent authority. This is what section 31 speaks. It was a case where the party acquired the property without the permission of the authority. And the question arose whether such transaction regarding the purchase of the property registered by registered document, whether he will get any right title interest in the property. The Honorable Apex Court held after overruling several Honorable High Court's judgments, which says that no, a post facto permission can be given. The Honorable Apex Court says nothing doing. When a specific prohibition is there, coupled with sanction and penalty, that what is the effect? Effect is, say, 500 rupees fine, or the government has a right to cancel such document or can initiate suo motu proceedings. So that is only provision. Whether it is taken or not, proceedings are taken out or not is not relevant. What is relevant is whether the statute says so. So that is relevant. The section, paragraph 14, for that purpose I read. I will go through hurriedly. The avowed object of Section 31 of the 73 Act was thus to minimize the drainage of foreign exchange by way of repatriation of income from immovable property and sale proceeds in case of disposal of property by a person who is not a citizen of India. It is noticed from the title of Section 31 is to put restriction on acquisition, holding, and disposal of immovable property in India by foreigners, non-citizens. We deem it apposite to reproduce Section 31 of the Act as applicable at a relevant time. The same reads that restriction on so and so. No person who is not a citizen of India and no company other than a banking company which is not incorporated under any law in force in India or in which the non-resident interest is more than 40% shall accept with the previous general or special permission of Reserve Bank, acquire or hold or transfer or dispose of by sale, mortgage, lease, deed, gift, settlement or otherwise any immovable property situated in India, provided that nothing in this subsection shall apply to the acquisition or transfer of any such property by way of lease for a period of not exceeding 5 years. Lastly, a relevant provision provided further that if before the expiry of a period of 90 days from the date on which the application was received by the Reserve Bank, that is in relation to the deemed permission. Now, then we go to paragraph 20. After discussing various judgments held by the apex court, para 20. It is well established. Am I with my notes? Para 20, because after paragraph 19 bold is written, thereafter in paragraph 19 itself there is 20, 21, 22 are mentioned. Okay, we may skip that. Yes, bro. It is well established. It starts with that. There are 20. Am I with my notes? Yes. Yes, I'm sorry. It is well established that a contract is void if prohibited by a statute under a penalty, even without express declaration that a contract is void, because such a penalty implies a prohibition. Further, it is settled that prohibition and negative words can rarely be directory. In the present dispensation provided under Section 31 of 73 Act, read with Section 47, 50 and 63 of the same Act, although it may be a case of seeking previous permission, it is the nature of prohibition as observed by 3-judge bench of this court in the case of Manalal so-and-so. In every case where statute imposes, this is the proposition, that in every case where a statute imposes a penalty for doing an act, though the act is not prohibited, yet the thing is unlawful, because it is not intended that a statute would impose a penalty for a lawful act. When penalty is imposed by a statute for the purpose of preventing something from being done on some ground of public policy, the thing prohibited, if done, will be treated as void, even though the penalty, if imposed, is not enforceable. We may usefully reproduce paragraph 18 to 22 of the said reported decision. We may not read the entire thing. Then 21. The appellant has invited our attention to the dictum in Union of India versus so-and-so, that where a contract express or implied is expressly or by implication forbidden by statute, no court will lend its assistance to give it effect. Further, a contract is void if prohibited by a statute under a penalty, even without express declaration that the contract is void, because such a penalty implies a prohibition. Similarly, in the case of Union of India versus so-and-so, 2012 1 SCC, the court opined that the contract would be lawful unless the consideration and object thereof is of such a nature that if permitted, it would defeat the provisions of law, and in such a case, the consideration or object is unlawful and would become void, and that unless the effect of an agreement results in performance of an unlawful act, an agreement which is otherwise legal cannot be held to be void, and if the effect of an agreement did not result in performance of an unlawful act, as a matter of public policy, the court should refuse to declare the contract void with a view to save the bargain entered into by the parties and the solemn promises made thereunder. The court adverted to the exposition in the earlier decision of so and so as to what makes an agreement which is otherwise legal void is that its performance is impossible even by disobedience of law. Then, my lord, paragraph 26. In light of the general policy, may I read?
Yes.
Yes. That foreigners should not be permitted allowed to deal with real estate in India, the peremptory condition of seeking previous permission of RBI before engaging in transactions specified in section 31 of the Act, and the consequence of penalty in case of contravention. The transfer of immovable property situated in India by a person who is not a citizen of India without previous permission of RBI must be regarded as unenforceable and by implication a prohibited act that can be avoided by RBI and also by anyone who is affected directly or indirectly by such a transaction. There is no reason to deny a remedy to such a person who is directly or indirectly affected by such a transaction. He can set up challenge thereto by direct action or even by way of collateral or indirect challenge. Anyone affected has a right to challenge such an action, my lord, which is of a void transaction. Paragraph 27, my lord. In other words, until permission is accorded by RBI, it would not be lawful contract or agreement within the meaning of section 10, read with section 23 of the Contract Act. For it remains forbidden transaction unless permission is obtained from the RBI. The fact that the transaction can be taken forward after grant of permission by RBI does not make the transaction any less forbidden at the time it is entered into. It would nevertheless be a case of transaction opposed to public policy and thus unlawful. In this view of the matter, the appellant must succeed and would be entitled for the reliefs claimed in original suit so and so for declaration that the gift deed dated so and supplementary deed dated so in favor of respondent number 1 are invalid, unenforceable, and not binding on the plaintiff. A fortiori, the plaintiff is entitled for possession of the suit property from respondent number 1 and persons claiming through them at measuring 12306 square feet and also mean profits for the relevant period for which separate inquiry needs to be initiated under order so and so. Then we're coming to paragraph 38. The conclusions follow. We hold that the condition pre-indicated in section 31 of 1973 Act of obtaining previous general or special permission of RBI for transfer or disposal of immovable property situated in India by sale or mortgage by a person who is not a citizen of India is mandatory. Until such permission is accorded, in law, the transfer cannot be given effect to, and for contravening with the requirement, the concerned person may be visited with penalty under section 50 and other consequences provided in 73 Act. Hence, the trial court as well as the High Court committed manifest error in dismissing the suit filed by the plaintiff for declaration in respect of the suit property. And for consequential relief referred to therein in paragraph 40, the last paragraph. In view of the above, the appeal is allowed. Impugned judgment and decree so and so is set aside. Instead, OS so and so, this is so and so stands decreed in toto in favor of plaintiff. The appellant, being legal representative of the plaintiff, is entitled for possession of the suit property, being the owner thereof, and also for mean profits of the relevant so and so order accordingly. So when he was dispossessed by such illegal document, he had also filed this suit. Suit was dismissed all throughout, except the Honorable Apex Court found favor on the ground that it is opposed to section 10 and 23 of the Contract Act, being opposed to public policy. There are other judgments also, which I have pointed out in relation to opposed to public policy. I may give it to the Honorable Court as well as to my learned friend. Here's the document, here's the judgment at serial number 5. Serial number 5, but next one, yes.
The earlier judgment is not in this list.
Yes, Manoj.
The earlier judgment that you read,
Yes, Manoj.
it is not in this list.
No, no, no. That is not in this list, Manoj. This one is the latest, Manoj, on the subject under section 23 of the Contract Act. So along with this serial number 7, it is to be added, or adding with serial number, I would say. Serial number 5 as 5A. That judgment can be added as 5A, on which I recently cited. So referring to page 32. This judgment has been referred to in my later judgment also, Manoj. Mandalal Khetan's case, Manoj, we read it in that also. So this has been referred to in my latest judgment. There is 2021 AIJEL, which I gave it to Manoj. That is also by Honorable 3 judges. And in para 21 itself, this judgment has been referred. And approved. Mandalal's case. Read it also. Yes, Mandalal's case. Case is relied on serial number 2, Manoj, of the one, Manoj, which I cited. So that has been relied upon by the Honorable Appellate Court. So I need not read again to take your lordship's time. Now, so far as section 22 is concerned, the judgment at serial number 4 is a clear answer to this in relation to undivided land. Baburam versus Santok Singh. Page 21. In paragraph 7, we'll read paragraph 13 onwards later, but in paragraph 7, it is important to note that the Honorable Apex Court has noted that when this act came and whether it has got a overriding effect on other acts. Because one would always say that under section 44 of the Transfer of Property Act, an undivided sharer has a right to transfer the property. But he cannot give any possession. The restriction of law is only to that extent. And also in respect of the dwelling house. We are not concerned with the dwelling house. We are concerned with only the agricultural land in question. Now, in paragraph 7, in internal page 25, the act came into force on 17th June 1956. Section 22 has remained unchanged since the enactment. While considering the effect of section 22, section 4(2) may be required to be looked into. Am I with my lords?
Yes.
Yes. However, section 4(2) as originally enacted has since then been omitted by the Hindu Succession Act Amended Act 2005. Before such omission, section 4 as originally enacted was as under overriding effect. Save as otherwise expressly provided in this act, any text, rule, interpretation of Hindu law or any custom or usage as part of law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act. B. Any other law for immediate in force immediately before the commencement of this act shall cease to apply to Hindus insofar as it is inconsistent with any provisions contained in this act. For the removal of doubts, it is hereby declared that nothing contained in this act shall be deemed to affect the provision of any law for the time being in force, provided for prevention of fragmentation of agricultural holdings or for fixation of selling so and so. Section 22 of the Act is as under. Now that has been quoted. Preferential right to acquire property in certain cases where after the commencement of this Act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in class 1 of the schedule, and any one of such heir proposes to transfer his or her interest in the property of business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. Meaning thereby it presupposes that you shall either take consent or shall say that I am going to sell my undivided share at a price X. Are you ready to purchase at a price X? The consideration for which an interest in the property of the deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by a court of law on application being made in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all cost or incident to the application. Now, so first case wherein, in paragraph 8 onwards, various cases have been considered where section 22 is interpreted. We shall straightway go to para 13 onwards. Various judgments have been discussed in paragraph 11, that what a particular court held. Orissa court, Punjab court, Mysore court, Orissa again, then SCC, Punjab and Haryana, so all, and Bombay. All those judgments considered. In paragraph 13, it is said this. In the aforesaid background, we are called upon to decide applicability of section 22 of the Act in respect of the agricultural lands. Before we consider the issue in question, we must refer to the decision of this court in Vaijanath and so and so. In that case, matters pertaining to intestacy and succession relating to joint family property, including agricultural land, were dealt with by a state law which had received the present assent of precedent following observation of this court are relevant for the present purposes. There is no exclusion of agricultural lands from entry 5, which covers will, intestacy and succession, as also joint family and partition. Although entry 6 of concurrent list refers to transfer of property other than agricultural land, agriculture as well as land, including transfer and alienation of agricultural land, are placed under entries 14 and 18 of the state list. Therefore, it is quite apparent that the legislature of the state of Hyderabad was competent to enact legislation which dealt with intestacy and succession relating to joint family property, including agricultural land. The language of Hindu Women's Right to Property Act 1937 as enacted in state of Hyderabad is as general as the original act. The words property as well as interest in joint family property are wide enough to cover agricultural lands also. Therefore, on an interpretation of Hindu Women's Right to Property Act as enacted by state of Hyderabad, the act covers agricultural land. As the federal court has noted in the aforesaid judgment, the Hindu Women's Right to Property Act is a remedial act seeking to mitigate hardship of the widow regarding the inheritance under the Hindu law prior to the enactment of 1937, and it ought to receive a beneficial interpretation. Beneficial interpretation in the present context would clearly cover agricultural lands under the word property. This act received the assent of precedent under article so and so. So then there is a short judgment, only paragraph 14. When the federal court was called upon to consider the matter, entry number so and so had inter alia dealt with transfer, alienation and devolution of agricultural land. It was in the exclusive domain of the provincial legislatures. The idea that the provincial legislature were alone entitled to deal with matters relating to transfer, alienation and devolution of agricultural land was again made clear in the list number 3 by expression succession, save as regards agricultural land, which dealt with concurrent powers. The provincial legislature has thus exclusive competence with regard to the transfer, alienation and devolution of agricultural land. In the circumstances, the federal court has answered the first question that the provisions of Hindu women's right to so and so would not regulate succession to agricultural lands in the provinces. But the situation underwent considerable change after the Constitution of India is adopted. The subjects as per alienation of agricultural land are retained in the state list in the form of entry 18. What it wants to convey is, with respect, that if a particular state, if has regulated particular state by way of, say, if it is agricultural land, Bombay Tenancy, now Gujarat Tenancy Act, if that regulates the succession, but that doesn't regulate succession in our case also. Gujarat has not made any other rules or section of inheritance. Family members, they say. So it is referable to that. But the subject devolution was taken out, as against entry number 7 of list 3, where the subject succession came with express qualification, save as regards agricultural lands. That qualification is now conspicuously absent in comparable entry 5 in the present list 3. The expression entry 5 today is intestacy and succession, meaning thereby it covers all. Then paragraph 16. In the present case, it is nobody's case that the matter relating to succession to an interest in agricultural land is in any way dealt with by the state legislation operating in state of Himachal Pradesh, since that was the case arising from Himachal Pradesh, or that such legislation must prevail in accordance with the principles under Article 254 of the Constitution of India. If there is special act, then obviously that will follow. The field is occupied only by Section 22 of the Act, insofar as state of Himachal Pradesh is concerned. My submission is that even in with respect to Gujarat, there is no special act by the state government. The High Court was therefore absolutely right in holding that Section 22 of the Act would operate in respect of succession to agricultural lands in the state. Though succession to an agricultural land is otherwise dealt with under Section 22 of the Act, the provisions of Section 4(2) of the Act before its omission had made it clear that the provisions of the Act would not apply in cases inter alia of devolution of tenancy rights in respect of agricultural holdings. Thus, effect of Section 4(2) of the Act before its deletion was quite clear that though the general field of succession, including in respect of agricultural lands, was dealt with under Section 22 of the Act, so far as devolution of tenancy rights with respect to agricultural holdings were concerned, the provision of Section 22 would be inapplicable. The High Court of Bombay was therefore absolutely right in its conclusion. However, with the deletion of Section 4(2), now there is no exception to the applicability of Section 22 of the Act to the agricultural land. We now turn upon the next stage of discussion, even if it is accepted that the provision of Section 22 would apply in respect of succession to agricultural lands. The question still remains whether the preferential right would be enjoyed by one or more of the heirs. Would that part also be within the competence of the Parliament, that is the right in or over the land tenures are within the exclusive competence of the state legislature under entry 18 of list 2 of the Constitution. Preemption laws enacted by state legislatures are examples where preferential rights have been conferred upon certain categories and classes of holders in case of certain transfers of agricultural lands. Whether conferring a preferential right by Section 22 would be consistent with the basic idea and principles is questioned. We may consider the matter with following 3 illustrations. Then 3 illustrations have been given. 1, 3 persons unrelated to each other. We are not that one. If those 3 persons are real brothers, illustration B, were real brothers, sisters, and had jointly purchased an agricultural land, here they have inherited. Investing their own funds, again like the above scenario, the right of preemption will have to be purely in accordance with relevant provision of the state legislation. But if very same 3 persons had inherited, this is the case applicable to us, clause C, inherited an agricultural land holding, and one of them was desirous of disposing his or her interest in the holding, the principle of Section 22 would step in. I hope I am clear about this. The reason is clear. the source of title or interest of any of the heirs in the third illustration is purely through the succession which is recognized in terms of the provisions of this act, that is the Succession Act. Since the right of interest itself is conferred by the provision of this act, the manner in which said right can be exercised has also been specified in the very same legislation. Therefore, the content of preferential right cannot be disassociated in the present case from the principles of succession. They are both part of the same concept. When Parliament thought of conferring the rights of succession, this is a very important paragraph, rights of succession in respect of various properties, including agricultural holdings, it put a qualification on the right to transfer to an outsider and gave preferential right to the other heirs with a designed object. Under the Shastric law, the interest of a co-partner would devolve by principle of survivorship, to which the exception was made by virtue of Section 6 of the Act. If the conditions stipulated in Section 6 were satisfied, the devolution of such interest of deceased would not go by survivorship, but in accordance with the provisions of the Act, since the right itself in certain cases were created for the first time by the provisions of the Act. It was thought fit to put a qualification so that the properties belonging to the family would be held within the family to the extent possible, and no outsider would easily be planted in the family properties. In our view, it is with this objective that the preferential right was conferred upon the remaining heirs in case any of the heir was desirous of transferring his interest in the property that he received by way of succession under the Act. We therefore conclude that the preferential right given to an heir of a Hindu under Section 22 of the Act is applicable even if the property in question is an agricultural land. Because, my lord, the present land is an agricultural land. The High Court was right in affirming the judgment and decree so and so, so and so, so and so, some of which have been referred, which have held contrary, which have that stands overruled. So the court came to the conclusion that it is a correct proposition whereby the Honorable High Court had cancelled the document. And that Honorable High Court's judgment has been confirmed in this judgment of Babu Ram's case. So on two counts, as I said so, under Section 22 of Hindu succession, as well as the other act, my lord, which I am referring to is that Fragmentation Act. Under Fragmentation Act, area-wise, so far as Gandhinagar is concerned, 2-acre land is considered as the block. Minimum area which is contemplated, minimum area which is determined under sections 5 and 6 of the Act, my lord, this Gujarat Prevention and Fragmentation Act, 1947. Two sections are relevant. One is Section 8, 9 and 31. These are the three sections I would refer to. There is a specific prohibition under Section 8. If I can continue before. Yes. Section 8 says, no land in any area shall be transferred or partitioned so to create a fragment. The land in question is 2 acres land. Original land, which were held as impartible estate so far as undivided agricultural field is concerned between two brothers. They are 2 acres, approximately 2 acre 0.1 or like that. So when it is to be divided, it will create a fragment less than 2 acres. Now, no land in any local area shall be transferred or partitioned so as to create a fragment. It cannot be transferred, so there is a prohibition. Section 9 says penalty for transfer or partition contrary to provisions and it says that the transfer or partition of any land contrary to the provision of this act shall be void. So when 2 acres land came to be divided, say even by imaginary transaction of sale, they say that it is divided. So it goes to 1 acre, goes to defendant number 2, 1 acre remains with the present plaintiff and his brothers. So both become fragment. So there is a total prohibition that it cannot be transferred so as to create a fragment. So far as Gandhinagar is concerned, my lord, I reiterate that as per the schedule attended and appended to this act, my lord, of Prevention of Fragmentation and Consolidation Act, my learned friend is an authority on that, my lord, that what is a fragment. So far as
Though I'm not an authority, I would submit that what is being contended, my friend, is not factually correct law. That is what limited submission that I want to make. ગાંધીનગરમાં 2 એકર ગાંધીનગરમાં 2 એકર જે કહ્યું, બેઝિકલી જરાયત જમીન હોય તો 2 એકર અને ક્યારીની હોય તો 20 ગુંઠા. That is the distinction. આટલું correction.
This is Jarayat land.
ના, એવું તમે જાણો છો, આપણે everyone knows ના કહેશો, તમે જાણો છો, તમે જાણો છો એ કહો મને.
Sir, if he is saying something, acknowledge it. You are an authority. Don't say no to it.
I plead ignorance. My friend knows this. My friend knows this, but I plead ignorance. I do not know that, at least because on record there is nothing that whether the land is Jarayat land or Kyari land.
That is a separate issue, sir.
No, that is the issue, because my friend submitted.
But I was saying that acknowledge that he's saying that you are the authority in this respect.
My friend is generous enough. My friend is generous enough, but I must say that there is marked distinction between these two. ક્યારીની જમીન હોય તો 20 ગુંઠા અને જરાયત હોય તો 2 એકર. Actually તો I am going to submit, even this cannot be looked into, that I am going to submit. પણ એ પછી આ તો ફક્ત એક મુદ્દા પૂરતું જ્યારે બોલ્યા ત્યારે હું કહું છું.
So that would be my submission.
Sir, can we continue just after 2 minutes?
Yes.
Thank you. Yes.
The exposition of law is quite clear on these 2 points. Then just I'm going through the additional evidence application, Exhibit 42.
Exhibit 54.
Exhibit 54. 44, the Honorable.
54. The application you gave on 2nd of May.
Yes, that's correct.
That is Exhibit 54.
That is Exhibit 54. And the list is 42. The 42 came correct. Anyway, I stand corrected. List doesn't have going on.
That documents are listed.
Application of the appellant under order 4127 of CPC.
42.
Okay. 42 4127 ચોખ્ખું છે અને પછી એના પહેલા પેલી index મૂક્યો છે. The index comes after this application, correct?
So with this application,
yes,
while Exhibit 54, you have not filed any list. Directly the documents are there after the application.
Correct. But the Honorable Court said that this index will be regarded as a list. But I may file separately also. There is no-
तो थर्ड एडीजे कोर्ट ने इसको
इसमें तो है, पर ये नई फाइल की तो इसमें वो लिस्ट नहीं आएगा.
55 નું લિસ્ટ થશે ને, આ 55 નું લિસ્ટ થશે ને, જો પેલું 54 હોય તો અરજી વાળી.
But there is no list on 55.
લિસ્ટ તો છે
હા હું સાહેબ એ જ કહું છું કે ઇન્ડેક્સ જે મેં આપી છે પહેલા 2 પાના છે ઇન્ડેક્સ એ ઇન્ડેક્સ હવે મારું લિસ્ટ બની જશે.
So it should be kept with this.
હા
You
it
want to
should be
say?
kept with that. Correct.
Okay.
એ ઉલટા
But then what will be exhibit 42?
Exhibit 42 શું છે મને ખ્યાલ નથી.
Actually,
જે ઇન્ડેક્સ
For additional
હા, હા. મેં જે એપ્લિકેશન આપી હતી
એક એપ્લિકેશન આવી
હા
એ ફિક્સ ફોર હિયરિંગ રાખી
કરેક્ટ
એની સાથે પેલું હાઈકોર્ટના પેલા મુજબ આગળ ઇન્ડેક્સ કર્યું
મેં આગળ ઇન્ડેક્સ
એટલે આ થર્ડ એડીજે કોર્ટમાં હતી ને એટલે ત્યાંથી આ ઇન્ડેક્સ નો 42 એક્ઝિબિટ થઈ ગયું
એટલે એને 42 આપ્યો.
એને એટલે ઉલટું.
that is application plus documents. That is exhibit 42.
Correct. Application plus
Now
documents.
you had filed this new application or rather the new copy. So you should have filed one list also
Or
after application.
all right.
One
I shall
list
file. I
with
shall file
documents.
accordingly so that there can be a another list exhibit. So and
Yes.
so.
Otherwise, I have to see the list there and then
No, no,
document
correct.
it in this.
Correct. I quite see the point.
List यहाँ देखनी पड़ेगी document.
हाँ.
इसमें.
I will just go through this, Manoj, and
You
we'll
can do it
try to
afterwards.
resolve the anomaly. Resolve the anomaly situation.
Just file one copy of that list
Yes, yes,
to be kept along with these documents.
very true. I have to file another application for audit 4127.
No, it is here. Application is all right.
Given exhibit 54.
Yes, after application and before these documents, there should be one list.
Correct. Documents are there. along with
Documents
it?
are there.
Okay, I appreciate that. So I will only produce the list
Yes,
without this application again.
yes.
That's true. Manoj.
Only the list.
Those documents, yes.
Only the list. Documents are here.
હા, કોકુ આપણે જે કહીએ, yes. That's very true.
Yes.
Lord, in that application, I have reproduced order 4127. That principles which are
And the reason is that these are executed after the filing of this appeal.
Exactly. After the judgment, these are the documents which have come into existence, whose genuineness is not questioned, and opportunity of
Not
evidence
admitted also.
No.
Not questioned, but not admitted also.
are not admitted. Yes, not admitted.
Yes.
But they are government record only, but I have not produced anything which is contrary to, or I mean a private document. The land is both survey numbers 889/1 and 889/2 is subjected to the Town Planning Act. It is the TP scheme number 13 of Wavol. So these are those documents of 2019.
What is the effect of these documents?
Yes, the effect of this document is that a final plot is sought to be given, which can be seen at page 26. I would say. Copy include. Yes. And the communication is. There is a communication dated 1/2/1990, 2019, which says that the scheme is sanctioned. Because the map shows, I have also given map to my learned friend also, that initially 889/1 and 889/2 were different. What has been given is a final plot 245, which is a rectangle plot. So far as sale deed is concerned, it is only of 889/1. The sale deed which has been executed by defendant number 1 in favor of defendant number 2 is 889/1 only. What has been taken into the sweep of this Town Planning Act is both numbers, and in lieu thereof, this FP is given 245. Only smaller part is only overlapping. Rest of the things are not overlapping. So the land which has gone from survey number 889/1 and 889/2 has been surrendered by me, by the plaintiffs, to the authority, and in lieu of them, they have handed over the certificate regarding Pauti. It is mentioned 22/2/19. નગર રચના યોજનાના કબજા સોંપવા લેવા અંગેની પાવતી. So they have issued that certificate regarding the possession receipt.
So now
It
you
has
are
been
having
given
the
to all
possession of whole of the plot number 245.
Yes, my lord, whole of the plot 245.
The
has been
defendant
given
number
to us.
1 or 2 are not having any possession.
No, no, no. They are not at all. This is what, and the on, I mean, I'm the last person to say, my lord, that when a scheme is sanctioned, it becomes part of the law under section 65, that it's a settled proposition. Previously, there was no frontage to the TP road at all. Now there is a frontage, which is specifically given. We have surrendered 889/1 and 889/2. And in lieu thereof, FP 245 actual possession have been handed over. Thereafter is the Honorable High Court's order, which I have produced, which authenticity, I mean, one would not be questioning. Then, after the Honorable High Court's order, my learned friend's client tried to trespass in the property, the new final plot, for which a complaint is made to DSP Gandhinagar. And a report is also given by the police inspector that yes, defendant number 2 has tried to enter in. And for that, it should be proceeded under Land Grabbing Act. That is the report which has been filed by the authority on 19/5/2021, page 35A. I think paging will differ. That is document serial number 8.
It is there. क्या आपको तो इसमें डॉक्यूमेंट थे पहले वो निकाल के इसके साथ लगाएं उसके डॉक्यूमेंट्स यहाँ लगा दें नहीं तो उसके साथ नहीं है ये अलग से कुछ भी क्या बट इसका एग्जिट 42 उसको कर दिया उसके पीछे जो डॉक्यूमेंट्स थे हाँ वो यही है इसमें से निकाल दिए हाँ वो यही और क्या ये जो लिस्ट ऑफ डॉक्यूमेंट वो उसके आगे लगे हाँ वो तो मैं समझ गया हाँ पर डॉक्यूमेंट्स दोबारा फाइल नहीं है ना वो उसमें से ही निकाल दिए तो उस पे ऐसा कर सकते हैं ये एप्लीकेशन यहाँ पे लगा हाँ ओके.
And then comes the public notice which has been issued and his reply that is also placed on record. These are all subsequent developments to show the conduct of the parties and the truth of the facts. I will produce that list, Manoj.
Will these documents, if you prove them,
Yes,
will have an impact
yes.
on the present appeal?
Why I say so? Because when the learned judge has said that it is opposed to, I mean, that it is contrary to the Prevention of Fragmentation Act. But then after stopping at that, the learned judge ought to have said that any act, a transfer contrary to Fragmentation Act would be hit by section 23. Therefore, the transaction is to be declared null and void, because otherwise the defense is under section 44 of the Transfer of Property Act. we will go for suit for partition. But I have prayed for cancellation of that document, that declare that document as void and not binding to me. Now, the court has given that declaration. But so far as the pinpoint, arguments are concerned regarding why it is bad, it is opposed to that act, correct. It is prohibited by that law, that is also correct. But then what is the effect? That consequential reasonings are lacking, as a matter of fact, regarding it being violative of section 23, the transaction goes off. Because any
So that is all right.
yes,
But what I am saying is, you say that you have been allotted this TP 245
yes,
in lieu of 889(1) and 889(2).
yes.
If the judgment, suppose one line is there now, that wherever reference is made to 889(1) and 889(2), the same may be read as 245. Why this evidence is required?
Evidence is required for two reasons. Because after the Honorable High Court directed that during the appeal also the parties will maintain status quo. The defendant number 2 admitted in his cross-examination in the trial court that he is not having possession. I can point out that paragraph and that sentence. He admitted that he is not in possession. After the Honorable Court, Honorable High Court said that parties to maintain status quo during the pendency of the appeal, he tried to create a...
Whether you are claiming some relief that he may not interfere with your possession?
Yes, but that is why the status quo orders were passed by the Honorable High Court.
In this very suit?
Yes, my lord, in this very suit, in this very litigation.
Then you can go in contempt.
No, my lord, the contempt, he has tried. I am not saying that he has dispossessed me. He has tried. Because he has no business to do it. Because he himself has admitted.
No issue has been framed on that regarding injunction.
That is the precise point, my lord. That during the suit, he has admitted that he is not in possession. Then when he came in possession, sir, I am putting a question to myself. The Honorable High Court also said that the parties are directed to maintain status quo during the pendency of the appeal in RTS proceedings. That has been stated. Now, thereafter in 2020 and 21, he tried to create a situation whereby trying to do fencing. So I immediately rushed to DSP saying that, sir, he should be prevented and he cannot be allowed to enter, because that would also amount to violation of the Honorable Court's order, which was passed with consensus that, all right, the status quo will be maintained. What status quo? When the suit came to be disposed of, he admitted that he is not in possession of the property. The mention in the sale deed that north side portion is sold and south side portion remains with you, this is all obliterated as a matter of fact. So what has been sold to him has never remained at all. He was sold 889 by one half undivided portion. But it is mentioned that no, it is divided one and you have been given. But in the cross-examination, he admitted that it is undivided land and he is not in possession. What more is required, Manoj? So that is the reason that this subsequent evidence should be on record so as to see that it is I who is in possession. His sale deed is totally illegal and void. Once it is void, it is not binding to me, it is not binding to this property. So he will not get any benefit under section 44 of the Transfer of Property Act for filing even suit for partition, which he has never filed. But he cannot use his might or power, Manoj, to grab the property. That is the reason that I had to produce the police complaint.
Sir, out of these 7 issues,
yes,
this shows that your only relief is regarding declaration.
Yes. If I see, Manoj, that
વાદી એવું સાબિત કરે છે કે દાવાવાળી
13A,
જમીન
yes,
વાદીની
yes.
વડીલોપાર્જિત જમીન છે.
No, so far as the prayer in the suit is concerned, I'm just reading that paragraph 13A of the suit. District, sub-district, Gandhinagar na ગામ વાવોલની સીમમાં આવે સર્વે નંબર 889/1 ની અડધ ભાગની આટલાની જમીનનો રજીસ્ટર્ડ દસ્તાવેજ 24/7/95 ના રોજ કરેલ વેચાણ દસ્તાવેજ ખોટો, ગેરકાયદેસર, હક અધિકાર
That is
વગરનો
declaration.
તેમજ રદબાતલ છે તેવું ઠરાવી આપો. તેમજ આ દસ્તાવેજના આધારે પ્રતિવાદી નંબર 2 ને કોઈ હક અધિકાર પ્રાપ્ત થતા નથી તેવું ઠરાવી આપો. તેમજ આ દસ્તાવેજનો ઉપયોગ કરી સરકારી રેવન્યુ રેકોર્ડમાં ફેરફાર નોંધ પડાવવા કાર્યવાહી કરાવે નહીં. તેમજ પ્રતિવાદી જાતે કે તેમના નોકરો એજન્ટ વગેરે દાવાવાળી મિલકતમાં પ્રવેશ કરાવે નહીં. તેમજ અમો વાદીના કબજા ભોગવટામાં હરકત અંતરાય કરાવે નહીં. તેઓ વાદીના લાભમાં પ્રતિવાદીઓ વિરુદ્ધ કાયમી જાતોનો મનયુક્ત આપો. In one paragraph, all reliefs have been prayed, and that has been granted, not according to my submission.
But no issue was framed regarding this.
That is true, my lord.
And
Unfortunately,
you had not filed any application
for
under order
yes,
1405.
exactly for recasting of issues, my lord,
Yes.
under 14, order 14. The
And even now your prayer is not regarding
my
that
lord,
issue.
issue is only this. Issue what is framed is શું એવું સાબિત થાય છે કે પ્રતિવાદી નંબર 2 ની તરફેણમાં થયેલ દસ્તાવેજ જે તે સમયે પ્રવર્તમાન કાયદા મુજબ થઈ શકે નહીં ને રદબાતલ છે. So this is the issue, my lord, which covers section 22 as of Succession Act as well as the breach of the
That is regarding declaration.
Fragmentation Act, my lord.
That is regarding your declaration prayer.
Correct.
Regarding your prayer for injunction,
Injunction prayer is very much made, but
no issue is framed.
no, the honorable court said શું હુકમ ને હુકમનામું. In that the court said that suit is not maintainable. So when the suit is not maintainable, what relief can the court
That
give?
is at the time of judgment.
Yes, at the time of judgment.
Before that, you did not file an application that this issue has not been framed.
Lord, the issue number 2 is વાદી વારસાઈ હક્કે દાવાવાળી જમીનના કુલ સ્વતંત્ર માલિક કબજેદાર થયા છે. A half-hearted issues are framed. Whether plaintiff is
Without
the
any
exclusive
objection
owner-
from any of the sides.
That's true, my lord. And that is why, my lord, this is a case which requires that it should be referred to the trial court for appropriate issue, my lord, which in my respectful submission would be
Not now, sir.
Yes.
Had both of you agreed at the beginning, I would have. Not now.
No. With regard to the additional evidence,
Right now also, I do not.
with regard to the
I will
additional
try to satisfy your honor that this appeal is required to be dismissed. I will.
After hearing the arguments,
yes.
मेरी मेहनत खराब मत करो अब कि मैं वहां भेज दूं.
नहीं.
Absolutely.
Now I decide.
Yes, Your
No,
Honor.
no.
That is what we
Under,
want.
under
That is-
order 41, it is your lordship who has to decide it. But if there is no, I mean, if I am permitted to read, my lord, order 41. Kindly say this. Sure.
ठीक है.
These are provisions I have quoted so that the honorable court may not have to open the book even. My lord. Order 41, Rule 25, where appellate court may frame issues and refer them to trial court whose decree appealed from. So, under 26A, there is also a provision, my lord, Order 41, 26A, where appellate court remands the case under Rule 23 or 23A, or frames issues and refers them for trial under Rule 25. It shall fix a date for the appearance of the parties before the court from whose decree the appeal was preferred, for the purpose of receiving the directions of that court as to further proceeding with the suit. Now, 27A says this, my lord, regarding the additional evidence. Order 41, 27. Now, in light of the above, next page, my lord, I have said this, my lord, that these two issues can be framed in view of the subsequent circumstances of getting final plot in original plot and partly outside original plot in TP scheme number 13 so and so, in 88-1 by so and so, original plot 245, final plot 245, whether the plaintiff proves that the possession of the suit property bearing new FP is handed over by the town planning authority to the plaintiff and his brothers. 1B, whether the plaintiff proves that defendant's sale deed being in teeth of Section 7 of Fragmentation Act without any permission of collector and in violation of Section 22 of the Hindu Succession Act renders the document void and illegal, and to be declared inoperative and not binding to the heirs of the Babar by Somabe Patel. Further direction under 4126A. The learned trial court be directed to permit additional evidence and give opportunity to the parties to lead evidence in respect of the issues above named, and the parties are directed to appear before trial court by so and so date, and learned trial court to return the evidence to the appellant court together with the findings thereon with reasons on or before so and so. Then the honorable court can decide this appeal as a whole, because these lacunas are there, that lacunas are required to be filled up, because otherwise the party will not get real justice. Even if the honorable court is saying, the trial court, unfortunately, my lord, with greatest respect to the trial court as well, the trial court said the suit is not maintainable because necessary parties are not joined. Only on that ground my suit is thrown out. Otherwise, the court would have said that I am entitled to the reliefs, because the sale deed is already declared illegal on both the counts, as a matter of fact, that their consents of co-owners are not taken, and it is in violation of Fragmentation Act. But then the necessary corollary in relation to Section 23 of the Contract Act and the law on the subject is not considered by the trial, that it can be declared void on these grounds. That is not considered at all, my lord. So based on that, my lord, my humble submission is that this is a case which requires the framing of the issues, and the matter can be remanded for this purpose only. And opportunity to both the sides, so there is no prejudice.
There is no application for framing of issues as of now.
No, but when the court is remanding the matter to the trial court, there is a necessary law, my lord. The law itself says that the honorable court can do this, my lord. May I read, my lord, that provision? The necessary provision is this, 26A. I have mentioned it, my lord. Where the appellate court remands a case under rule so and so, or frames issues and refers them for trial. So I have suggested two issues. I have suggested these two issues and refers them for trial under rule 25. That is the rule 25.
That is
It shall
only
fix a
if the
date.
case is remanded.
Yes, my lord, I am saying so. If the case is remanded for this purpose in view of the subsequent development of facts.
I am saying there is no need to remand the case. Then,
Can I leave it to the honorable court, my lord?
regarding your application under Order 41, Rule 27.
Yes.
If it is rejected, there is no nothing to say that it can be remanded or not. If it is allowed, I can either remand it back for taking fresh evidence.
Yes.
Or I can direct the parties to lead evidence here.
Correct. No difficulty. No difficulty.
So in any case, what I am saying is there is no need to remand the case.
Very true, my lord. Very true. I wholeheartedly agree to the honorable court.
Whether evidence is required or not, that will be decided.
Very true, my lord. Very true.
But I am making it clear that I am not remanding it back.
interested in as such remand, my lord, only to see that these subsequent facts are taken on record.
That will be decided whether it is required or not.
Grateful to me.
Anything else you want to submit?
I have submitted that compilation of judgments. I don't want to read all and every.
Sir,
judgment.
just do one thing.
Yes, bro.
Highlight the relevant portions, the paragraphs which you want to refer.
All right. Highlight also?
Yes.
I shall highlight also.
That will be easier for
All
me.
right. All right. Now I've written the paragraphs in my index. I've
Index
written
it
the
is there.
paragraphs,
But if you highlight, it will
still
be better.
Grateful to Manoj. Grateful. Highlight paragraph.
No,
Yes, sir. You want to start today or on the next date?
Any next date,
When? Which date you want?
any convenient date or the one.
Take now, for that time.
એક સેશન જશે ને આ આખું બધું એમનું જે છે બધું બતાવવું પડશે
2 કલાક 3 to 5.
ઓલમોસ્ટ
अच्छा
મને વાંધો
नहीं उसको तो रहने दो. लोग गलत है। So, 16th of July.
July.
Can it not be on 20 Malhotra? 20 June?
સાહેબ જુલાઈ માં છે.
હા એટલે what is just April? I am just asking to the other court so that
અથવા
the
for
fact
that
are-
matter the
for that it-
request that my friend is making is કે કોઈ પણ સેટરડે રાખે એટલે
હા,
એ આવી
20મી
શકે.
20મી જો અનુકૂળ હોય તો.
હા, હોય તો આપણને વાંધો નહીં. મને તો વાંધો જ નથી.
20 June. So I'm having 4 cases in which witnesses have been called.
Oh,
No problem.
then any
It will
day-
not be
you
proper
are
to
not
send any
able-
witness
શનિ
back.
રાખજો એટલે એમને ફાવે. મને વાંધો નથી પણ એમને ફાવે શનિવાર. હું તો રોજ આવું છું પણ એમને પેલું
20
ત્યાંથી આવવાનું
પછી
એટલે
4 જુલાઈ ના
4 જુલાઈ
ગયો છે.
જોઈ લો 4 જુલાઈ 4 જુલાઈ કે 18 જુલાઈ બેમાંથી એક આવશે. 4
4th of July.
Grateful.
Obliged.
I will be submitting the separate list, Malhotra. So I may be permitted, I will do it in the
No,
course of the day or tomorrow.
what I have directed him that list which is exhibited as 42 be kept with this.
Correct.
So that it will be easier.
Got
You need not file any separate list.
Got Right. Shall we take it?
Yes, sir, please. हाँ जी
सर क्रिमिनल बोर्ड में सेल नंबर 4.
जी अब उसके बाद आए नहीं, मैं वेट करता रहा.
मुझे ऐसा लगा इट इज माय फॉल्ट. मुझे ऐसा
मैंने
लगा,
कहा
सर,
5 मिनट रुकिए,
कि
फाइल
देख
निकलवा
लेते
लूं.
हैं. अब फिर सर
क्योंकि वारंट मेन फाइल में इशू हुए हैं तो फाइल निकलवा लूं कि क्यों इशू हुए, क्या है. आप किसके लिए हैं? अच्छा, साथ ही हैं.
वो एक बंदा और था जो बोलता नहीं था सर एट द टाइम ऑफ कॉस्ट ऑफ 3000 रुपीज.
अब इसमें ये बताइए कि ये इस केस में आया कब था, वारंट कैंसिलेशन वाली डेट छोड़ के कभी आया है? कब?
वो कॉस्ट किया उससे पहले 2 बार उसने उसकी एक बार सगाई वाला बार आया था, दूसरी बार शादी वाला. दैट टाइम ऑनरेबल कोर्ट have mentioned why you are putting same reason each and every time.
अभी आप कह रहे हैं कि फादर की डेथ के बाद वो अकेला है जो सारी सामाजिक जो जिम्मेवारियां निभानी है. एक आरोपी ये कह सकता है कि मैं सामाजिक जिम्मेवारी है इसलिए मेरे पास टाइम नहीं है कोर्ट में आने का.
जो
यही तो कह रहे हो आप.
नहीं सर,
वर्ड ये नहीं पर कह तो यही रहे हो.
पोलाइटली मेंशन.
सर मैं इसलिए कह रहा हूँ ना, वर्ड से नहीं है बट बात तो यही है.
सर वो हिंदी भाषी है ना, सही सही में लैंग्वेज प्रॉब्लम मुझे भी हुआ. वो मैं उससे बताऊं कि भाई तू आजा आजा, तो बोला सर मैं टाइल्स का काम करता हूँ, मैंने इसकी मम्मी को भी बुलाया.
सर ये काम से तो ये नहीं चलेगा ना कि वो ये काम करता है इसलिए आरोपी नहीं आएगा.
हम अभी बाउंडेड, वी आर बाउंडेड कि
सर आगे का छोड़िए, अभी तक का देखिए, अभी तक का बताइए मुझे.
इनको सर जुडिशियल कस्टडी में लिया है. इससे पहले 2 बार नहीं आया. इससे पहले 3000 कॉस्ट पर उसको छोड़ा गया था. उससे पहले वो 2 बार नहीं था. રીઝન वो था कि
અમારા પિતાજીનું તેમજ અમારા મોટા સગા ભાઈનું અવસાન થઈ ગયેલ હોવાને કારણે તે પછી અમોના તારીખ 8/2/26 ના રોજથી લગ્ન થયેલ હોવાથી અમારા કુટુંબમાં અમારી માતા અને નાના ભાઈનું તેમજ અમારી પત્ની એ રીતના સભ્યોનું ભરણ પોષણ કરવાની જવાબદારી અમારા શિરે છે. અને અતિ મહત્વની પરિસ્થિતિ એવી છે કે અમે એકમાત્ર કમાનાર વ્યક્તિ છીએ. આવા સંજોગોના કારણે તેમજ રોજ રોજ છૂટક મજદૂરી કરી જે પણ રૂપિયા મળે તેના આધારે અમારું તથા અમારા કુટુંબનું ભરણ પોષણ કરતા આવેલ છીએ.
we are trying to convince honorable court.
सर मेरे
हमारा
पास 70% आरोपियों की यही पोजीशन होगी.
इसलिए इनका माताजी को भी हाजिर रखा है सर.
माताजी क्या करेंगी इसमें?
कि वो भी दुखी है कि मेरा बच्चा अंदर है. मैं बोला उसको हर रोज
सर, अंदर से दुखी हैं, लेकिन वो कभी कोर्ट में ना आए उससे कोई फर्क नहीं पड़ रहा है.
मैं सहमत हूँ सर, मैं सहमत हूँ. इसलिए सर मुझे भी शर्मिंदगी हुई. मैं उस केस में सर रियली में मैं हाजिर नहीं हो पाया. फिर रिक्वेस्ट है सर आपको.
सर इसके वारंट्स रद्द हुए थे 18/3
जी सर।
आधार 4 या नहीं आया, बे 4 या नहीं आया,
5
बे 5 या नहीं आया,
और
फ्रंट 6 आया।
चला आया सर।
एक बार वारंट रद्द कर दिया तब भी इसने आना छोड़ दिया।
उसको उसने सही में गलत किया है सर। मुझे तो ऐसा लगता है कि
तो सर सजा किस चीज की होती है? गलत करने की होती है।
गलती करता है।
फिर गलती की सजा मिलती है, इसने गलती की है, आप और क्या कहेंगे?
मैं एक सही में बात बताऊं सर, ये वकालतनामा भी मैंने उसमें साइन नहीं किया, इन लोगों के साथ में खड़ा हूँ, तो मुझे भी सब बुरा लग रहा है कि ये बताने के बावजूद बंदा नहीं आ रहा है, तो सर सही में मेरे को बुरा लग रहा है, लेकिन सर एक चांस दो सर।
सर वही तो दिया था।
आई आई एग्री, आप बोलो अभी, ठीक है ना, मेरा साइन भी नहीं है, मेरे को देख आंख पड़ेगी। बोलो आप।
जी सर, रिक्वेस्ट
मुझे कोई ग्राउंड दे दो कि ये बंदा इस लायक है कि एप्लीकेशन अलाउ करूं। आगे क्या करोगे क्या होगा वो नहीं, ये आरोपी इस लायक है, उसका कोई भी ग्राउंड दे दो एक।
सर, अभी उनकी नई नई शादी हुई है।
अच्छा, जिसकी नई शादी हुई हो
नहीं नहीं सर, ऐसा
उस आरोपी को कोई कोर्ट में ना बुलाए।
नहीं, सॉरी सर, ऐसा नहीं।
हाँ,
क्या सर, मम्मी भी, उनके कोई मतलब उनके पिताजी नहीं है, उनका भाई, उनके भाई नहीं है, अभी जो भी है वो वही है। और आगे से सर वो हर डेट में हाजिर रह गया टाइम।
सर अभी तो मेरे भी पिताजी नहीं है, मेरी फैमिली में मैं ही अकेला कमाता हूँ, कल से कोर्ट आना छोड़ दूं? घर बैठे सैलरी मिलेगी?
नहीं सर।
फिर ये क्या ग्राउंड हुआ? ये तो कोई ग्राउंड नहीं है सर।
ऑनरेबल को
Sorry.
जो भी फरमाएगी वो सब पालन करेंगे
सर अभी तो मेरे पास टाइम नहीं बचा, मैं कल ऑर्डर कर पाऊंगा, कल देखते हैं। हाँ कर दो, तो मैंने देख लिया, तो 10,000 उसके वो नौकरी लिखी हुई है।